All right, everyone. Good morning, Global Aviation family members. I did not hear any good mornings, and maybe only a few are having a good morning today. Shall we start over? Okay. Good morning, Global Aviation family members. Good morning. I hope that you had a wonderful day at day one here at 2024 ICAO Legal Seminar. It's now time for us to brightly start the morning, the day two. Well, this is an event that is hosted by ICAO as well as the Korean Ministry of Land, Infrastructure and Transport. My name is Shin Ji-ye, serving as the MC for you, starting from yesterday until today. Well, let me remind you that this seminar is a paperless seminar, which means that we're providing all the presentation documents through the QR code that has been printed at the back of your name tag. And today we will be going through the session 3, 4, 5, and end the day with the closing ceremony. So I hope that you will be here with us until the very end and have a meaningful time here with us. Well, having said that, we're going to now begin the session 3 on the topic of facilitation. As mentioned yesterday, this year, 2024, has been marked as the year of facilitation. I think there will be a lot of abundant things being discussed through the session. So let's bring the moderator up to the stage. This session will be moderated by Mr. Alessio Quaranta, the President of European Civil Aviation Conference. Please give him a big round of applause. And of course, we will be joined by 4 spectacular speakers today. First of all, let's invite to the stage Mr. Andrew Oppola, the legal officer at ICAO. Welcome. And next, let me introduce to you Ms. Leslie McIntoshie, the Corporate Secretary and Acting General Counsel of IATA. Welcome. And now it's time to call upon Mr. Cho Young-ju, the partner attorney at law firm Lee & Co. And as for the last but not the least, we have Ms. Erika Barga, the legal officer from the Legal Affairs and External Relations Bureau at ICAO. Welcome. And now I'm going to leave the floor to the moderator.
Thank you very much and good morning, everybody. First of all, let me thank once again ICAO and the Ministry for Land, Infrastructure and Transport of the Republic of Korea, first of all for inviting me today for moderating this very interesting session, but also for the lovely dinner offered yesterday. It was very, very nice. And of course, it is a true honor for me to be here today and to lead such a stimulating discussion on the topic of facilitation. The goal today is to examine the topic of facilitation from different perspectives in the legal key, creating an inclusive, informative, and respectful conversation in which everyone can contribute their experiences and perspective. Before we dive into discussion, I would like to make a few remarks about the panel format. During this session, we will have the privilege to hearing a presentation from our distinguished speakers already presented before, each of whom will bring a unique perspective on the topic we are addressing. These presentations will provide us with a valuable opportunity to deepen our understanding of facilitation and to examine different angles and points of view. At the end of all presentations made by our speakers, there will be a Q&A session, which will be an important interactive moment and will allow for exchange of knowledge and further exploration of the topic discussed. But now, let's explore the concept of facilitation in more depth. In the field of civil aviation, you know better than me, facilitation are those activities, resources, and procedures implemented to make the movement of aircraft passengers and goods through airports smoother and less burdensome, while ensuring compliance with national and international regulation and standards. Specifically, facilitation are realized by the continuous improvement of control processes and service procedures. They require cooperation among the different sectors of the community, each of which operates under its own responsibilities and competencies. And facilitation, of course, involves mainly four groups of stakeholders: states, aircraft operators, airport operators, and of course, customers. And the effective management of air transport facilitation improve aviation services quality and cost effectiveness, boosting civil aviation overall. Facilitation activities contribute significantly to development and have a positive economic impact. Facing new challenges, facilitation are essential for delivering adaptable responsible, notably evident during events such as, unfortunately, the COVID-19 pandemic, or in preventing emerging threats in security or immigration, such as terrorism or human trafficking. Proactive actions by all stakeholders are necessary to ensure the resilience of systems, processes, and technology. Furthermore, over time travel itself has become an experience, whether we are taking about a journey with leisure purposes, work, or necessity. Therefore, new needs have arisen in order to perceive the travel experience as increasingly enjoyable, safe, and inclusive. Just think of increasing efforts aimed at meeting the needs of passengers with reduced mobility or with disabilities. In the context of civil aviation, facilitation also involves a series of legal aspects, including the management of biometric data, privacy, and data protection. The use of data and digitalization can improve the efficiency and security of checks and border processes. However, it is essential to ensure that the collection and use of such data respects passengers' privacy and comply with data protection regulation. The standard and recommended practices on facilitation outlined in Annex 9 to the Chicago Convention have been instrumental since the adoption in 1949. And this year marks the 70th anniversary of Annex 9, which has been reminded to us several times yesterday. Recognized by ICAO Council as the year of facilitation. After 75 years, facilitation system is gaining increasing importance considering both technological progress and the challenges faced by civil aviation from various perspectives. Furthermore, the increasing number of flights and passengers are expanding the audience using airplanes and airports. This, along with the rising average of the population, mobility and health-related issues associated with this phenomenon make the topic increasingly relevant. Annex 9 covers a broad spectrum of topics linked to aviation, requiring collaborative efforts among various stakeholders, including those not directly involved in the aviation sector, such as customs, law enforcement, and public health authorities. This is the reason why the celebration of the Year of Facilitation may contribute to elevate the attention by other stakeholders of government outside the aviation domain, providing for improved collaboration and implementation nationally. Now, let's move on to listen the valuable perspective of our speaker on this crucial topic. And we welcome as the fifth speaker, who will guide us through the legal milestone in air transport facilitation during 75 years. Mr. Ender Opolot, the legal officer, Legal Affairs and External Relations Bureau of ICAO. Mr. Opolot graduated with a Bachelor of Laws degree from Makerere University in Kampala, Uganda, and is admitted to the Ugandan bar. He obtained an LLM in Air and Space Law from the University of Leiden in the Netherlands. He worked for over 10 years as Chief Legal Advisor for the National Civil Aviation Administration of Botswana, and now he handles various portfolio on ICAO works in the legal field, among others aviation security, including cybersecurity, air transport policy, conflicts of interest in civil aviation, environmental protection, and climate change and global air law training. Please, Andrew, the floor is yours.
Good morning, everyone, and I'm happy to be here again for the second time in 2 days. Thank you, Alessio, for the introduction. I think you made my work much easier by introducing the topic. Facilitation is, I like to think of it as a third pillar of international civil aviation. It is less discussed generally compared to aviation security and safety, and it's therefore most timely and fitting that it is included in the program for today for the first time at this event, at least for the last 10 years since I've been aware of it. And this is notable because facilitation is about laws, rules, and regulations for entry into a state and departure from it. Today, the aviation sector handles almost 100,000 flights a day, transporting about 12 million passengers and 20 billion worth of goods. And this presentation will highlight the various legal tools in air transport that have served the objective of helping people and goods move around the world and thereby empowering economic growth for the last 75 years since the adoption of Annex 9, as you've heard, on 25 March 1949. But first, to remind ourselves what is facilitation, and I'll start by talking about the movies. Are you familiar with the documentary Border Security? Anyone? Not quite. You can look it up afterwards, but Border Security is a riveting TV documentary that follows the Canadian and US border services officers as they process people and goods at international airports. Some of the action takes place at Vancouver International Airport, where 20,000 people get into Canada every day. And so this documentary gives you an inside look into how the frontline officers from border services apply facilitation rules in the task of separating genuine travelers and genuine goods from those that are not. I recommend for you to watch Border Security. More formally then, going to the definition of facilitation. Facilitation, as you've heard from Alessio, is concerned with ensuring or enabling the efficient movement of aircraft, crew, passengers, and cargo into and out of the airspace and upon arrival at or departure from the designated airport. So this efficiency is realized through the establishment and application of laws relating to entry and departure clearance for flights, immigration, customs, border control, and quarantine. ICAO's role, together with that of the member states, is to ensure that there is a high degree of uniformity in regulations, procedures, and organization. Annex 17 has a definition for aviation security, I think, and so does Annex 19 for safety, but Annex 9 doesn't have a definition for facilitation, But there is a formal definition for facilitation that you'll find in the facilitation manual, which is guidance prepared by ICAO. And in that manual, it is stated that facilitation refers to activities in connection with the clearance of aircraft, people, and goods through the formalities at international borders and the standards and regulations developed for that purpose. In effect, the aircraft, what does this mean in effect? That the aircraft must be authorized to fly across international borders. There should be formalities for people, cargo and goods to enter. The rules should be in place to deal with inadmissible persons, deportees, and even people who have lost their travel documents. There must be infrastructure and facilities to handle the entry and processing of goods and persons. There must be alternative places to land if the designated international airport is not available for some reason. And there must be a seamless border management through the use of passenger data. And it must also be ensured that air transport does not become a means for spreading communicable diseases and trafficking in people or wildlife species. All agencies involved must be equipped with the means to administer regulations relating to those activities. And that introduces us to who are the stakeholders in facilitation. As you've just heard, it covers a wide range of disciplines across multiple government agencies or departments that are responsible for the implementation of the facilitation legal framework. In addition to civil aviation administrations and regulators, you have national border control agencies, police, immigration, customs, animal and plant quarantine. You also have industry actors such as the airlines, air operators, airports, cargo handling organizations that also have a role to play to comply and minimize operational costs as well as delays and also avoid congestion. To those operating stakeholders, I would add tourism and travel firms. As you may be aware, 50% of tourists travel by air. There must be a high degree of cooperation among these players to ensure continuous improvement of control processes. Having gone at length about describing the facilitation environment, I'm curious at this point to ask if you could please raise your hand if your work involves or is connected to facilitation. I can hardly see any hands raised. So I should stop here because nobody, okay. Okay. Okay, a couple of you are involved. I should say as well that for those that are not, facilitation also probably concerns you as a passenger. Those of you who came here by air. Passengers as well should cooperate in improving facilitation by making themselves familiar with the regulations and complying with them. You should not, for example, be showing up at an airport without a visa or electronic travel authorization or other requirements. You slow down the process because of that. So this is the legal framework for facilitation, the Chicago Convention, of course, and the key provision appears in Article 22, where states are obliged to adopt all practical measures to facilitate and expedite navigation by aircraft and prevent unnecessary delays, especially in the administration of laws relating to immigration and quarantine. So ICAO then adopts the standards and recommended practices, the SARPs, and formulates policies and guidance material to support this process. There were originally 89 SARPs in the first edition of Annex 9, which have now grown to 442 SARPs in the 16th edition of Annex 9. You heard all this from the Honorable Minister from Malawi last night at the dinner about the evolution of Annex 9. And just to recap, it was in 1947 that the Council established the Air Transport Committee with a mandate to make proposals for standards and recommended practices relating to air transport. And thereafter, in 1949, the first edition was adopted. Some of the other significant, there have been 16 editions of Annex 9, so some of the significant additions are highlighted on this slide, beginning with, in 1982, the addition of provisions relating to national facilitation programs and national and airport facilitation committees, which bring together stakeholders to achieve the objective of easing processes. And then in 2005, the 12th edition introduced provisions on machine-readable travel documents, or MRTDs, biometric technologies, travel documents, and also assistance to accident aircraft victims. And then in 2018, we had provisions relating to advanced passenger information and automated border control systems. Most recently, the 16th edition updated provisions on public health emergencies, health-proof documents, relief and repatriation flights, which were added in the wake of the COVID-19 pandemic, and also provisions on facilitation of persons with disabilities, and measures on trafficking of persons were also added, as well as provisions on passenger name record and PNR data, and the ICAO public key directory known as PKD. Chicago Convention. So the mandate for all that is done in the realm of facilitation derives its authority from the Chicago Convention, and there are as many as 10 provisions in the convention that directly impact facilitation. And to cite some of the main ones, they're all there, but I should say the central provisions are Articles 22 and 23, and under Article 22 concerns the facilitation of border control formalities, which I just mentioned, obliges contracting states to prevent unnecessary delays in air travel. And in Article 23, the states undertake to establish customs and immigration procedures in accordance with the practices established pursuant to the convention. And this is the enabling provision for the development of standards in those areas. In Article 37 and 38, the organization adopts recommended practices which states are obliged to transpose standards into their national legislation, unless, of course, they file a difference. And then going to Annex 9 itself, it elaborates the measures and practices that states must introduce for facilitation. And when you look at this arrangement, it almost follows the trajectory of a flight, beginning with the aircraft entering into national airspace at the top left-hand corner. It lands at a designated airport. Passengers disembark with their hand luggage. Checked luggage is removed and transferred for processing in the terminal. Unaccompanied bags and cargo are taken to the warehouse for processing and clearance. Special categories of passengers, deportees, inadmissible persons, are isolated for special handling. And while in the terminal, you have facilities and services for inbound, outbound, and transit passengers, immigration, public health, and customs clearance. There are also arrangements to land at an alternative place if you do not have, if there is no availability at the designated place. And also for special flights that are not regular commercial flights, such as relief flights and flights for search and rescue. And then finally, in the appendices, you have standard forms for passenger and cargo manifests, disinsection of aircraft, and crew certificates. This is not new. You heard this yesterday from my senior colleague, Mr. Verhagen, yesterday while discussing safety, about the distinction between the definition of standards and recommended practices in 18 annexes, with Annex 9 being different from all of them. You can spot the differences on that slide. On the left is the definition which applies to the 18 annexes, most of them in the realm of safety, and on the right is the definition for Annex 9. The reason being that Annex 9 is about practices and processes, and so the definition avoids using terminologies that would relate to mechanical or tangible objects. Another element to look out for is the relationship between facilitation and aviation security. Long processing times are often attributed to the application of security controls. Some have said that there is a need to balance facilitation with security, and some of these provisions appear to suggest that some kind of balancing act is being attempted, but the reality is that aviation security and facilitation are not competing fields. They are related fields, but not competing fields. They share the same objective of speedy and efficient processing for on-time departures. Aviation security, on the one hand, ensures that there is no unlawful interference with the safety of the flight, while facilitation ensures that the right people with the right credentials get onto the aircraft. There's plenty of guidance from ICAO. Those are examples of that on various topics that we have talked about. I also wanted to touch on facilitation in emergencies to say that the requirement for facilitation is not eliminated when there's an unusual or extraordinary occurrence which affects the regular and normal air transport operations. When there's a hijacking, or there's a bomb threat, or an aircraft diversion, the legal framework maintains the requirement for states to facilitate the affected flights. And the treaties on this slide cover such situation where a flight has been diverted, and the continuing theme is that measures must be taken to avoid unnecessary delays and allow the passengers to continue on their journey. That's just an example of unruly and standards on unruly and disruptive passengers, and I won't say very much there because I have a colleague who is going to speak about this later, only to note that if a flight has got to be diverted to disembark a disruptive passenger, it's an unexpected flight, and therefore needs to be facilitation needs to be provided on a priority basis, provide a landing slot, gate access, and agencies such as law enforcement to be on hand to take delivery of the disembarked passenger. These are specific subjects in facilitation. I'll just highlight one or two of them in the forthcoming slides. Assistance to accident victims. International flights, as you know, often carry passengers from many different nationalities. And in the event of an accident in one state, family members may need to travel to an aircraft accident site, a hospital, or other location in the state of occurrence on an urgent basis. and without prior preparation of normal entry requirements, and standard 8.42 addresses the need to facilitate such travel. Trafficking in persons is another topic, because aviation personnel at airports or on an aircraft can be the first or last line of defense against the transportation by air of victims of this kind of trafficking. So empowering them to recognize a potential victim or perpetrator and alert authorities expeditiously is a powerful tool that can be deployed to stop these acts. And this is still a recommended practice. In time, it will grow to become a standard, but there's plenty of guidance on this issue. These are some of the risks I've identified to facilitation, in the sense that these kinds of events often disrupt normal arrangements for facilitation of travel, but in spite of their occurrence, they shouldn't impact on facilitative processes. Instead, steps should be taken to introduce rational controls. And Chapter 1 of Annex 9 in particular highlights that states should take all necessary measures to ensure that minimum time and inconvenience is caused by the application of control requirements. And this applies even when these events occur. Finally, as you have heard, 2024 is designated by ICAO as the year of facilitation, and there is an ICAO Facilitation Global Summit taking place in Riyadh, in the Kingdom of Saudi Arabia, on the 21st and 22nd May under the theme Past, Present, and Future, 75 Years of Enabling Air Travel. The summit will focus on how to enhance the passenger experience through the effective implementation of several Annex 9 provisions. It will raise awareness about the regulatory framework for facilitation and highlight future opportunities, such as building resilience for public health risks in aviation, and highlight the benefits of using digital representation for safe and secure movement of travelers. And will also call for priorities to be given to existing or new activities that enhance the passenger experience. So please take the messages we share today here with you to Riyadh and beyond for the cause of air transport facilitation and economic development. I thank you.
Thank you, Andrew, for your insightful presentation. I think you have clearly demonstrated that facilitation is really a cross-domain to all other subsectors in aviation, outlining how important is the legal framework in implementing in its implementation, let's say. But I think we will go back to this item later on, probably during our Q&A session. I think it's time to welcome Leslie McIntosh, Corporate Secretary and Acting General Counsel of IATA. Leslie has, in addition to a legal knowledge and expertise, a significant management experience in governance with strategic planning, organizational change, performance, and project management. She has been practicing aviation law since she joined the New Zealand Civil Aviation Authority in 1996 and has represented New Zealand and IATA in various international fora, including ICAO Legal Committee meetings, task forces, and ICAO assemblies. Please, Leslie, the floor is yours.
Thank you very much for that wonderful introduction. And I wanted to start off by extending my thanks to ICAO and the Ministry of Land, Infrastructure and Transport for inviting me to come. And we really appreciate the opportunity to present an industry perspective on an area that is very important to us. and very linked to facilitation. Thank you. Is that better? As Andrew was talking and listing all the areas where facilitation is important, where there are SARPs involved, I'm thinking of what I'm about to talk about, which is about data protection and data privacy, and which is fundamentally about the protection of personal information. And in that list, if you could think about all the times that you would have to use or collect personal information in that list, and that is really the topic of that we're talking about now. I'm going to talk about some emerging issues that airlines are facing and why these are important to our members, and why many of our privacy experts in our airlines are facing sleepless nights at the moment, and why we are bringing these to ICAO, to aviation legal professionals and privacy legal experts to try and find some answers to these problems. But before I get into the substantive part of the presentation, I want to emphasize that airlines, of course, recognize the need to protect personal data. We work fervently to comply, and we're not asking for airlines to be able to opt out of these important compliance requirements, but we need some consistency and we need some recognition of the special characteristics of civil aviation in the context of those. So I'm going to talk about the use of personal data for the physical transport of passengers and goods, not for the sales and marketing efforts that our airlines do. And I think that's an important distinction. Airlines aren't asking to be exempt from those regulations that apply to all areas of commerce at the moment. So this is a good look at the kind of data to think about. It's an iceberg. Above the waterline, these are the data that governments understand. It's information that's requested. It's API, PNR, health data, as we saw in COVID. Those are things we know about. There are other things above that line that maybe are emerging. We're working with the Legal Bureau and the Legal Committee on the Article 12 Task Force, which talks about information about offenses, which will include personal information that airlines will need to disclose for the purpose of collecting information about offenses. Below the waterline is a raft of other data that needs to be transferred. Airlines face a difficult situation. For example, a baggage handling contract might be 60 pages to protect bag tag numbers, which is personal information. There's 20 pages for EU data transfer clauses, 15 for the UK, 12 for China, 9 for Brazil, and 4 pages for the contract. So most of the contract is about protecting personal data in order to comply with different rules all around the world. So we haven't been to date really looking holistically about how the aviation regulatory framework and our obligations under the Chicago Convention interact with national data protection law. So what are the special characteristics of civil aviation that require us to look harder at this? Firstly, international data transfers are essential to the physical transport of passengers and goods across borders. Complex travel itineraries through different types of booking methods, both with the same carrier and with interline, all recognized as essential under our facilitation activities, result in different regimes applying. There is a requirement to transfer data in accordance with international obligations and the SARPs. An airline is a single entity operating in all states. That's a requirement under ASAs, and also a requirement under the aviation regulatory system and AOCs. You can't have different legal entities operating under one AOC. The booking process requires a single database. It's not split between different locations. All these elements are things that come into question when applying data privacy laws and data protection laws. It's also worth remembering that most of these laws were in response to a rise in social media and e-commerce. They didn't consider the unique or special characteristics of international civil aviation, and what does this mean in the context of data protection. It is very unique that we physically transport both the subject of the data, the personal data, from one jurisdiction to another, and that data. The transfer of data is required in order to conduct air transport. So as you can see that there are a number of, there's 3/4 of all states have some kind of data protection regulation. And yes, this has been happening over some time. And you might be saying, well, why are we bringing this to the attention now? It's because the issues are becoming sharper. The pandemic brought to light the importance of health information, which is considered sensitive information under many privacy regimes. And there is also an increasing enforcement of privacy laws. A big sharp issue that our airlines are facing is the requirements of the EU with respect to transferring data from one state to another, and the conflict between that requirement and the PNR issue. Data protection laws apply in almost every state. National or regional laws are inconsistent with each other. There are different concepts in some of the laws. The GDPR has concepts that are not apparent in other jurisdictions, and it's really necessary that we get some consistency so that there is a seamless ability to protect privacy as people travel across jurisdictions. The EU is this adequacy issue. So there is a requirement that when data is transferred into another state, the EU has an adequacy assessment to make over the laws of the other country. And there has been some issues, sharp issues, just in the last few months about this adequacy issue and the requirement to transfer PNR data, which I'll get to in a moment. Just to give an example, what data protections would apply in this situation? We've got Mary, who is a citizen of Canada, and she's traveling around Europe. And she books a flight departing from Spain to Brazil. The booking is to travel on an airline based in the US. Which data privacy or protection laws might apply to Mary? Is it the EU because she's in the EU? Is it Canada because she's a citizen of Canada? Is it Brazil because that's where she's going? Or is it the US? And what happens if the EU does not permit the sharing of PNR data with Brazil, where she's going? What happens then? How does an airline comply? Other considerations. There's often talk about the legal basis for processing personal information. That legal basis then gives an entity a reason to do so and can allow an entity to do so without offending the laws. The problem is that there are conflicting legal bases in most jurisdictions, in some jurisdictions. It's not just a conflicting legal base, it's a totally different concept. in the EU, you might have a legitimate purpose in doing it. But in some places, you have to have express consent every time. So there's a conflict. What does an airline do in transferring passengers? So I'm going to give another example, sharp example, but could be real. Our passenger is John. He's traveling from Calgary, Canada, to Algeria, and he's going through France to do so. He has cerebral palsy and requires a wheelchair and assistance throughout the duration of his travel. He has a Canadian airline on the first leg. He changes airlines in France, and then he lands in Algeria. The legal basis for the collection, processing, and international transfer varies between all three of those jurisdictions. And he also has sensitive information that must be transferred, that is his health information, all of which is required to be transferred in order to facilitate his travel. So it causes a problem for our airlines as they are dealing with this information. What jurisdiction do they comply with? How can they possibly comply with all of them? Is there a way that we can ensure that there is some consistency or ability for this to happen without coming into a compliance situation? Now the sharp issue, PNR implementation. So at the moment, there are almost 70, I think 68 countries that have PNR implemented. In 2018, there were only 25 states. So you can see that it's becoming sharper and sharper. And it will continue to grow as it's now a requirement under Annex 9. Under GDPR, there is a legal obligation that a third country is not recognized as it's not recognized as a justification to transfer information just because it's required, just because there's a legal obligation to do it. It needs to be to a country with adequate protection of personal data. And there has to be an assessment made that there is such adequate protection, and then there has to be a bilateral between those countries to do that. So this causes issues where third countries request PNR, they're obligated to do so, they're requiring it to do so. However, European carriers cannot comply. So what happens? There are situations where airlines are subject to fines. There's even threats of removing operating approvals under ASAs. There's a conflict between the ASA, which grants those rights, and the privacy laws. Is that discrimination? This will only get worse. To date, third countries have generally tolerated the situation, but there is a trend coming where, in fact, airlines are being fined for not complying with the PNR directive. And that is an issue that we are really noticing and causing a lot of difficulties. We've been made aware of one Gulf state that has insisted that all airlines provide PNR data in line with its laws, as it should, because that's a compliance issue. The penalties are equivalent to $50,000 per flight for non-compliance. And the Ministry of Foreign Affairs in that airline's home state is trying to get involved in making representations that this shouldn't happen. But what do we do now? We know of one member airline that was recommencing services in that same Gulf state and was threatened with the removal of route operating approvals because PNR data could not be provided because it would have been contrary to the laws of the home country of that airline. And that's despite the fact that there is an ASA governing it. So it's a huge difficulty. It's becoming more and more a difficulty. So what can we do? What can we do? What have we done to raise awareness of this issue, and what are we suggesting is a legal potential avenue to look at? So last September, we held a joint seminar with ICAO, and this seminar was incredibly successful. 200 attendees gathered to talk about the conflicting issues of data protection and civil aviation. It was attended by council members, privacy experts from airlines, CAAs, international organizations like the OECD and the Pilots Association. And it quickly, throughout the day of that seminar and in the discussions that have happened since, that things need to be set in motion. And that's how we've now come to develop a white paper. And I had hoped that it would be ready by now, but it's not quite yet. IATA has a group of privacy law experts within legal departments of airlines called our Privacy Law Working Group, and they have been working on this in connection with some experts from law firms and from other organizations. And it's about to be ready for release within the next couple of weeks. And it will focus on how the airlines feel this issue. What are the sharp issues for the airlines? What are the solutions that we think might become useful? The paper illustrates how airlines handle personal data, collecting, processing, retaining, and transferring it to other states and aviation stakeholders. And this includes examples of the challenges that are faced. In addition, we will demonstrate how important it is to recognize the special characteristics of international civil aviation, and we need to take these factors into account when assessing new privacy laws in particular. One of the issues, PNR, and how that can be managed is something that is discussed in the paper. And we've also done a review of the conflicting legal bases that I highlighted just very briefly, and how airlines have been handling these challenges. There's one example that will be focused on that I haven't mentioned, and that is data localization. And that is the requirement that data be processed in the jurisdiction of either the subject of the data or where the data originates from. And it makes operations very complicated. As I mentioned before, airlines can't be incorporated or have separate legal entities set up in each jurisdiction. It's a cost issue, but it's also a regulatory issue for airlines. So when data is localized, it can slow down processing times, affects decisions for flight planning and customer service. Cross-border data flow restrictions make international operations like booking, ticketing, and loyalty programs more challenging. Airlines are being put in a position where they potentially face huge penalties, even if compliance with one country's law may infringe the laws of another country. I'm running out of time, so I'm going to skip my other comments on the white paper just to say that it will be available very soon. Really, the purpose of the white paper is to think of a way forward. The issues are complex. There is a lot of discussions to be had. We think that other multilateral initiatives that are underway in the OECD, for example, might help with this issue. We think that it's important to have a multidisciplinary group to assess what solutions could be adopted for civil aviation. And we firmly believe that some guidance would be helpful. We're not advocating that there is an international instrument on this, but guidance material as a way to move forward on this. So I am almost run out of time, but I do want to stress that this is what we think would happen. We would think that working through ICAO with our assistance, with the OECD's assistance, and with some privacy experts' assistance, that we might be able to develop some high-level guidance material that might help states and airlines in complying with data privacy and in developing data privacy regulations. So thank you. I've run out of time.
Thank you, Leslie. Your presentation was really helpful in, in understanding the various legal implications in transferring personal data from one jurisdiction to another, especially when it comes to PRM, which are really increasing in their numbers, changing the shape of air transport nowadays. Before going to the next speaker, just one clarification from my side. Some of the slides presented by Leslie will be used also by Erica in her presentation later on, if I understand correctly. Please.
New slides.
New slide. Okay. Now let's welcome Ms. Young-Ju Cho, partner attorney at law, Lee and Co., which is one of the biggest law firm in Korea. In recognition of his distinguished service, Young-Ju received a Minister Commended Man of Merit Award by the Ministry of Land, Infrastructure and Transport. In fact, in addition to his practice on aviation regulations, including new areas in drone urban air mobility regulation, MAA, cross-border investment, and drafting various contracts, he has handled complex matters representing numerous foreign airlines in achieving permission for foreign international transportation service in Korea and offering legal advice to foreign and domestic airlines regarding any issue related to aviation regulations. Please, Young-Ju, the floor is yours.
Thank you again for inviting me to the ICAO conference legal seminar. This has been, I think, the third time I'm making a presentation here, and I'm, again, very honored to be part of the seminar. Now, I will try not to overlap any issues that Leslie presented. The data privacy laws conflicting in each jurisdictions right now here in the world is a major issue, especially the GDPR and the PNR issue is also a critical issue right now here in Korea. So the question is now, what I'll try to do is, so not to overlap with Leslie, is try to be focused mainly on the Korean law, Korean data privacy law, especially in the field of aviation. So as Leslie has pointed out, you know, there is enhanced personal data protection regulations, and the aviation sector faces challenges due to conflicting regulations across countries. And this complexity arises due to the sector's unique feature. As you know, wherein individuals from various nations are information principals, subject to diverse data protection frameworks. So currently, the significance of safeguarding data and personal information cannot be overstated. However, you know, the laws of each state conflict each other, and blending personal data protection regulations from different states. So these regulations frequently do not align with each other, causing difficulties. So let's try to at least understand the main issues here under Korean law. What I'll try to do is briefly explain you the major concepts in the Korean Personal Information Protection Act, and how the regulations, how it's processed, and then some cases here, majorly here under Korean law. So the major concept would be, of course, number one, what is personal information? Now, a personal information is an information of a living individual. And a personal information must identify a particular individual by his or her full name, or it could be a social security number, even a picture. And even an information that could be easily combined with other information to uniquely identify an individual that could also be regarded as personal information. So in cases whether or not there's an ease of combination, that's a determination reasonably considering time and cost, technology, used to identify an individual, that would be how you distinguish the easily combination. And there's also a concept of pseudonymized information. And in most jurisdictions, pseudonymized information is personal information. In some jurisdictions, they are not. And pseudonymized information is information incapable of uniquely identifying as an individual without the use or combination of information for restoration. But they are still regarded as personal information, whereas anonymized information under Korean law is not personal information, no longer capable of identifying an individual, even if additional information is used. We are of the understanding that EU, US, China also does not regard anonymized information as personal information, but in some jurisdictions, we wonder they do. And again, it's a living individual information, so information about a deceased person, corporate entity, organization, corporation, that's not personal information. And there are issues about behavioral information and ADID. The Korean Personal Information Protection Committee, the PIPC, has not yet made a conclusive opinion, but we would have to review those issues. And there's the concept of personal information controller. Then what is a personal information controller? It's a legal entity that processes personal information for the purpose of its work. Then what's the purpose of its work? Of course, excludes personal activities, private relationship. However, if you have an intent and continue, then whether the processing was done a single time doesn't matter. The intention is important. Then what are personal information files? Those are sets of personal information arranged or organized in systematic manner based on certain rules of search. But like one-time note-taking or documentation, those are not regarded as processing personal information files. There are some concepts to distinguish. One would be personal information handler, and another would be personal information processing industry. We will not go over these since we are, I should be running out of time. And there are some regulations under Korean law that protect personal information even more. One is Credit Information Use and Protection Act, and credit information is even protected more hardly than personal information. And then there is an act on the protection and use of location information. Location information here in Korea, you need a business license to conduct a business using location information. Then step-by-step issues in personal information processing. So the main issue is, of course, collecting and using. How do you collect and use personal information? The principle is, of course, number one, consent. And you must even notify in advance. And if any of the notified information is changed, notify again and obtain consent again. And also, you cannot use that information outside purpose use. And of course, there are exceptions. For major airlines, fortunately, not only where there's a law in Korea to comply with the legal obligation, not even that, but where necessary to fulfill a contract or take steps at the request of the data subject, that is also an exception in Korea. So let's say you want to implement an employment agreement, you want to implement the I would say air services, air purchase agreement with the customer, then There's some exception here under Korean law. However, these, of course, exceptions are existing on a very limited basis. Then there are third-party provisions and processing entrustments. So third-party provision is providing that personal information to a third party. Again, you need consent. And these consent is a separate consent from the consent to use and collect personal information. So you need to have a separate consent. Of course, there are exceptions. Again, if there is a special provision in the law, or if it's necessary to comply with the legal obligation, then there's an exception. In case of international air transportation, fortunately under Korean law, the Immigration Control Act that requesting for the passenger reservation that are PNR, and also the Aviation Security Act, it does search, give grounds of processing personal information. So there are some laws in Korea that let's provide those personal information to a third party. Again, purposes of providing that purposes other than which has received consent requires, of course, separate consent. And there is a concept that should be, to be noteworthy, which is third-party provision and processing entrustment. The processing entrustment is something different from just providing personal information. It's just processing entrustment. Again, this is different because it does not require prior consent. And it is similar to a third-party provision in a sense that personal information is transferred to a third party, but third-party provision is for the business processing and interest of the recipient, whereas processing entrustment is for the business processing and interest of the personal information controller. So that's the main difference. Entering into a personal information processing entrustment agreement and disclosing that entrusted task is needed, and that would be the significant difference. And most airlines have to deal with the cross-border transfer of personal information. Meaning of cross-border transfer, I think you all know what it means. Then what are the requirements? Of course, a separate consent is needed. Again, if you have a consent, then in most jurisdictions, if you have a separate consent, then that is normally okay. Whether there are exceptions. Exception applies where certain cross-border transfer is necessary for execution or performance of contracts on the premise that the above notification items has been disclosed, of course, to the person. And here in Korea, cross-border transfer is permitted where it is recognized that personal information protection system of the country or international organization to which the personal information is to be transferred is substantially equivalent to the Personal Information Protection Act of Korea. So Korea jurisdiction tries to allow cross-border transfer even without consent if they regard that personal information is substantially being protected in that other jurisdiction. However, the Korea government has not yet recognized any other government body yet, but we'll have to see. And this is, I think, a big development under Korean law in terms of data protection in aviation. Then destroying personal information, even destroying personal information, there's a law for that. When can you destroy it? Expiry, of course, or like canceling a membership. And there are, under Korean law, like, for example, the labor law says for 3 years, in 3 years you have to, destroy it. And again, you have to destroy in a form that cannot be restored or reproduced again. Then there is leakage. Leakage is a concept that happens, and then how should you react? You have to notify within 72 hours. If the data subjects whose contact information is known must post it on the website at least for 30 days. And report it to the Personal Information Protection Committee or the Korea Internet and Security Agency within 72 hours. And those are the two obligations. And the sanctions, the potential sanctions, when you look at them, number one, investigate. There could be an investigation. And then fines and penalties may be imposed. You can see the fines here. They are 3% of total revenue minus revenue not related to the violation. So there was a case, a penalty of even $750,000 US dollars. So it's not really a small amount. And the causal link between the violation of the law and the personal information leakages doesn't have to be even established. So you do not have to, the person does not have to prove there has been a causal link and then ask for damages. And there's even criminal punishment here under Korean law. So then what is the issue with airlines in Korea? Fortunately, no cases yet confirmed in which the Korean authority imposed penalties on airlines. The PIPC did discuss with the aviation industry officials on ways how to strengthen the level of personal information protections. That was last year around November. Well, fortunately, the aviation industry particularly emphasizing on restrictions, processing on sensitive information and unique identification information, compliance with PIPA was really discussed, and how to provide those personal information overseas. The PIPA did mention, though, that the airline, if without consent processes sensitive information to a third party, then the airline may be subject to the person in charge of the airline may be subject to imprisonment of 5 years and or less, or fine up to 50 million Korean won. Also, there's a penalty of 3% of its total sales, excluding of course sales that are not related to the violation, which we have seen earlier. And then another 30 million Korean fine could be levied. So this is not an easy issue, and but unfortunately until now there are no cases of the Korean authority actually harshly implementing it to foreign airlines yet. Let's look at some very I should say interesting funny cases. So there has even been a prison term for an unauthorized sale of personal information. It was in 2020. Somebody sold personal information and in exchange for money, so 1 year and 6 months of imprisonment, and another fine for approximately 301 million Korean won. That would be 224,000 US dollars. And is a last 4 digit of a mobile number. So there was an issue of police, the last 4 digit of mobile phone number that was leaked. Is that a personal information or not? The court ruled it can be easily combined with other relevant information, and then it is a personal information. So you can see how strict the Korean court regards personal information. And then a photograph, a portrait or likeness of a person. It was just a photograph with a cover letter. That is also regarded by the court of personal information. And then phone call records acquired during police investigation. Phone call records are also regarded personal information under Korean law, and that's how the Korean court sees it. Now, these are not really important issues. There are some amendments which could be a burden to airlines and the airline industry. Number one would be expanded imposition of penalties. So there could be much higher penalties in the future because the changed basis for calculating penalties from revenue related to the violation to total revenue. So the total revenue is a much larger concept compared to the revenue related to the violation. So this could become a burden, of course, for a lot of airlines. And also, Also, when obtaining consent to the processing of personal information, now the amended Korean law must allow the data subjects to freely decide whether to consent or not. Because, before there was kind of a practice that even if that, person did not consent, grant consent, it could be regarded as mandating consent. But that practice cannot be regarded anymore here in Korea. So also Korea is creating a right of data subjects to request of personal information controllers over a certain size to transfer personal information. So these are also some new regulation you can consider here under Korean law. So I have like 1 minute left. So one thing, just again, for the airline industry, there are conflicting jurisdictions, but again, under Korean law, there could be an imprisonment and even a penalty up to 3% of the total sales, and a fine again. And it's not just for providing that personal information, it's for not having received consent, not having processed it correctly, not having entrusted it correctly. They are all separately regulated, and so airlines and the airline industry should be all aware of it. And as Leslie has pointed out, the international community really needs some kind of a universal regulation to, so that no conflicts between jurisdictions occur. Thank you.
Thank you, Young-Ju, for sharing your expertise. It would be interesting to explore relation between data collection and artificial intelligence, because I think that if it could be useful, of course, in analyzing data, probably it's not too easy to be implemented in all jurisdictions, but we will come back to it if we will have time later on. Now, in conclusion, let's welcome Erika Varga. Erika is legal officer from the Legal Affairs and External Bureau of ICAO. Erika has a law master degree from the University Health in Budapest. From 2013 until her secondment to ICAO, she served as legal advisor in the DGCA head of the CAA of Hungary and Deputy Director General, and joined in 2007 the CAA of Hungary, working in different positions, lawyer at the legal department, and supporting the function of CAA. Please, Erika, the floor is yours. But of course, first of all, Leslie, for introducing some slides.
Thank you, and thank you for your patience. Just quickly, I wanted to share some data, the most up-to-date data on unruly passengers. And I think our concern is that there is a growing frequency and severity of the unruly and disruptive passenger behavior on aircraft, and it's a concern to everyone. This data that I'm showing is the 2023 data that is relatively new and raw, so there's some analysis that needs to be done, but I think it's useful to show it in the meantime. So I'm just trying to push next, yes. So essentially it's clear that it is rising. We have reports from 60 airlines. IATA has over 320 members, so you might say 60 is not representative, but we've kind of extracted based on what we've got. It seems to indicate that there's approximately 25,000 event reports from just 57 operators. So if you extrapolated that, it looks at a rate per 1,000 flights. And it's about one incident for each 480 flights in 2023 versus one incident for 568 flights in 2022, with about the same number of airlines reporting. So it indicates that it's rising. And I suppose the other thing is that not all incidents result in violence. Diving a little bit deeper into the data shows the kinds of indicators that we ask our reporters to classify. So generally, what I think is remarkable from this slide is that non-compliance is indicated at a really high level, increasing a lot in 2023. That non-compliance includes a number of things. It might include things that as from not wearing seat belts to not putting electronics away to smoking in laboratories. And so it's an increasing. While this doesn't necessarily mean that there's violence or abusive behavior, I think there are a number of incidents in that list that in fact do show a trend that that kind of behavior is also increasing. In 2023, physically abusive cases occurred in every 6,024 flights versus in 2022, every 17,240 flights. So it's quite an increase. So I just wanted to share those slides. And of course, Erica's going to talk a little bit more about what we can do about that. Thank you.
Good morning, ladies and gentlemen. Thank you very much, Leslie, for this very valuable introduction. I think it is very important to see the industry's perspective and the industry's data to understand better why it is so important for us to do something on unruly passengers. My topic today is basically the role of the Montreal Protocol 2014 in dealing with unruly and disruptive passengers. As we heard yesterday, the Montreal Protocol is one of the key air law treaties which will be promoted by ICAO. And actually, amongst these 6 key ILO treaties, the Montreal Protocol has the lowest ratification rate until today. So on one hand, as Leslie introduced, we see a rising number of disruptive and unruly passengers, which is a major safety issue. But on the other hand, we have, unfortunately, a pretty low ratification rate of the Montreal Protocol. So in my presentation today, I will try to highlight the achievements of the Montreal Protocol, why this is beneficial for the whole aviation community. And at the same time, we are trying to promote the ratification of the Montreal Protocol, of course. So if we look into the status of the Montreal Protocol, then we see that the protocol is amending the Convention on Offenses and Certain Other Acts committed on board of aircraft, which was signed in Tokyo in 1963. The protocol was done in Montreal on 4th of April 2014. We are just a few days after the 10th anniversary of this protocol, so this is another occasion actually to talk about this important legal instrument, and it is already in force since the 1st of January 2020. Currently, 47 states are parties of the protocol, and just to comparison, the Tokyo Convention has 187 parties for today. So this is the original convention which has been amended by the Montreal Protocol. So a bit about the Tokyo Convention. I am sure that most of you are familiar with the Tokyo Convention. So the Tokyo Convention applies to acts which may or do jeopardize safety of aircraft or persons or property therein, or good order and discipline on board. It is commonly agreed that this interpretation includes unruly and disruptive behavior as well, even if this expression does not appear in the Tokyo Convention as such. So even if this is not defined in the Tokyo Convention, this is a common agreement in the aviation community that we understand this as unruly and disruptive behavior as well. The state of registration is competent to exercise jurisdiction, and establishment of necessary jurisdiction is required by the states who ratified the convention. And moreover, this convention contains detailed rules for the power of the aircraft commander as well. So having said so, I want to look through a few reasons which were reasons for the modernization of this Tokyo Convention. So as we heard earlier, there is an increasing number of incidents of unruly and disruptive passenger events. I would like here to mention that we do not have any uniform reporting system. So as Leslie mentioned earlier, they are collecting data from their air carriers, but this is not a representative data collection because there is no reporting system. To my best knowledge, nowhere in the world exists such a reporting system which is focusing expressively on this unruly disruptive passenger events. So we don't really have the absolute appropriate data to deal with it. Another reason for modernization was that there are different laws and jurisdictions which are applicable. So it means that one specific behavior can be regarded in one state as offense, and in other state it is not an offense. So the thinking behind that was that it is very useful to have a harmonized list of offenses which could serve as a common framework of reference for all the states. Additionally, international conventions in aviation security are designed for particularly serious offenses such as sabotage and hijacking, and they are not specifically designed for less serious types of offenses or acts such as disruptive or unruly behavior of passengers. So the mixture of all these circumstances led basically to insufficient enforcement actions, even if this problem is raising and is a potential threat to aviation safety during the day-by-day operation. So what I would try, that I am trying just to highlight the main achievements of the protocols. These are the advantages what we can use if the countries are applying this protocol. So one of the main achievements is the extended jurisdiction. Jurisdiction is a main problem concerning the basic agreement. So while the Tokyo Convention requires the states of registry to establish appropriate jurisdiction over offenses committed on board of aircraft, the Montreal Protocol additionally requires the state of landing and the state of operator as well to establish appropriate jurisdiction. And additional to the state of registry, the state of landing and the state of operator have competencies also to exercise jurisdiction over offenses and acts committed on board. I just would like to highlight a distinction here between establishing appropriate jurisdiction, which is an obligation, and having competent or having the competency for exercising jurisdiction, which is a competence here. So there are two different things what we are talking here about. These are competing jurisdictions. I am fully aware that many countries have some concerns about, because just typically it is competing jurisdiction can be confusing. So it means that we have several states, several countries which can have competencies in jurisdictions. But the Montreal Protocol says, because of this, that states exercising jurisdiction shall coordinate with other states in case if there is information that other states conduct proceeding, investigations, or prosecutions in respect of the same act. So there is a coordination obligation amongst the states which could have possibly jurisdiction. Having said so, I just would like to show you a very simple example, operational example, just to understand maybe a bit better what's the difference between the Montreal Protocol and the Tokyo Convention. So we have country A, country B, and country C. Country A is state of registry, country B is state of operator and state of the destination, and country C is the state of landing, actually. So if there is an unruly passenger on board, which endangers safety, then the pilot in command can decide to return to country A. So returning to country A, that's the easiest way, return to the state of registry. Even under Tokyo Convention, so when we are talking about that these states, neither A, B, C states, They did not ratify the Montreal Protocol, so we are under the Tokyo Convention. Even in this case, if the flight returned with the unruly passenger on board to country A, there is no problem because country A, the state of registry, has jurisdiction, so they can make the appropriate enforcement action. In case if the pilot decides to continue the journey and not to return to the origin, but land in country B, as it was planned originally, then there is a problem, because we have an unruly passenger on board, landed in country B, and maybe police forces or local forces can make protocols, can make some enforcement actions, but actually the competence of jurisdiction is not at country B, is it at country A. The same problem appears if the flight is diverted because of this unruly behavior, so the pilot in command decides not to land in country B, but just to land in country C at an alternate airport, and based on the Tokyo Convention, the country C does not have any jurisdiction over this passenger, so that's again problematic. If these countries ratifying the Montreal Protocol, it would mean that all these three countries would have jurisdiction over this behavior, over this unruly passenger, which makes it much more easier to have appropriate enforcement actions. So basically, this is the very simple example just to explain the difference if a state ratified the Montreal Protocol or not, and using the Tokyo Convention on this. Sanctions. There is another achievement that serious offenses are usually subject in national legislations of criminal prosecutions. But if you look at disruptive and unruly behavior, this is, in contrary, often punished with civil and administrative sanctions, depending, of course, on the seriousness of the specific act. But this is mostly not a subject of criminal prosecution. So now there is a very common principle that sanctions should be efficient and effective against unruly and disruptive behavior, and it depends, of course, on the seriousness. There is a wide range of sanctions applicable, and there are to the discretion of the countries to decide which sanctions they apply based on their own sanction system. The Montreal Protocol does not prescribe any type of penalties or sanctions. There is a range of options for that, but there is an ICAO manual, I will refer to this later on, which provides us certain guidance on the element, on the administrative sanctions regime, which can be used. The Montreal Protocol expressively encourages states to make necessary measures, appropriate criminal, administrative, or any other forms of legal proceeding against the person who commits on board an offense or act which we consider as disruptive or unruly. Sanction and prosecution. So in case if the state of landing is exercising jurisdiction, it shall be considered if the offense is an offense in the state of operator 2. This means that if there is an act, it's an offense which is unlawful in its jurisdiction, in the jurisdiction of the state of landing, but it is not unlawful in the state of operator, sanctioning should be exercised with caution, because multiple states can have jurisdiction. Sanctioning should be exercised with the appropriate caution. This is also an achievement of the Montreal Protocol. And finally, I would like to stress the role of the in-flight security officers, which they are called also commonly air marshals. So the Montreal Protocol extended the legal recognition of in-flight security of officers. So the Tokyo Convention basically clarified the power of the commander, and the Montreal Protocol added provisions concerning the power of the air marshals or in-flight security officers. This means that air marshals or in-flight security officers may take reasonable preventive measures without the authorization of the commander under certain circumstances on board. I just would like to mention that in-flight security officers are deployed based on multilateral or bilateral agreements, and this is till the same rule applies. So if there is multilateral agreements or bilateral agreements which apply, then in-flight security officers can be on board. Otherwise, if that's not the case, that's not applicable, of course. So the Montreal Protocol did not change anything on the existing framework of the in-flight security officers. These are the main achievements, maybe, of the Montreal Protocol, which I wanted to highlight, but there are also some additional achievements connected with the Montreal Protocol. So first of all, yesterday we talked about definitions. Definitions are extremely important for us just to be able to understand what is for what applicable. That's generally for lawyers, legal people, definitions are the basis all the time. So I mentioned that unruly or disruptive behavior is not defined in the Tokyo Convention or in the Montreal Protocol, and there is a wide range of acts which are considered as unruly or disruptive. Commonly, we have an understanding that when we are talking about unruptive or disruptive behavior, we are referring to passengers who fail to respect the rules of conduct on board or to follow the instructions of the crew and create a threat to safety of flight, or disturb the order and discipline on board. This is our common understanding, but this is not written as a definition as such. So we do not have an exhaustive list of these acts. As we have seen during the previous years, during the pandemic, several new unruly behavior types appeared. For instance, not complying with wearing masks on board, or not complying with the social distance regulations, which have been different from state to state. But all the time, new behaviors appear, so this is very logical that we do not have an exhaustive list. However, we have DOC 10117, and in DOC 10117, we have a list of typical unruly and disruptive behavior, and this DOC has been updated to align with Montreal Protocol 2014 as well. However, as I mentioned, this is a non-exhaustive list, so states are encouraged to incorporate the list into their national legislation as far as practicable, of course. It means that this does not preclude states from establishing certain acts as subject to legal proceedings neither. There is a model legislation and guidance on administrative sanction regimes which should assist states to apply appropriately the Montreal Protocol. As I mentioned, this doc includes a model legislation on certain offenses committed on board of aircraft. This is Appendix A of this doc, and includes also a guidance for introducing an administrative sanctions regime on certain offenses committed on board aircraft, which is Appendix B of this doc. These are the main relevant documents, DOC 10034 and DOC 10117, which can be used by ratifying the Montreal Protocol. So ICAO encouraging all states to ratify this protocol in order to ensure effective and efficient enforcement actions against unruly and disruptive behavior. Thank you very much for your attention.
Thank you, Erika. It would be important to know if ICAO could take some steps in front of states, like my one, unfortunately, where it's still pending ratification process in order to convince the, let's say, between brackets, the reluctant states to ratify the convention. I think, unfortunately, we finish our time with time restriction, and unfortunately, we don't have space for questions from the audience. But my last duty would be to ask all of you to tribute a big applause to our speakers.
Yes, thank you very much. We're going to end the third session here and have a break until 11 o'clock. Well, I believe this was a session where we were able to learn about the legal framework and the data protection, as well as the Montreal Protocol as well. So once again, please give a big round of applause to all the speakers who have been joining us for the third session. And let's now move on to the break, and we'll see you all at the fourth session, 11 o'clock. Thank you very much. Kick off session 4, where we'll be learning about new mobility and aviation legal perspective. This session is going to be led by Mr. Lee Jae-won, the ambassador and permanent representative of the Republic of Korea on the Council to the ICAO. Let's welcome him to the stage with a big round of applause. And now let me introduce to you the speakers who will be joining the session. First of all, let's welcome to the stage Mr. Choi Seung-wook, the Director of Urban Air Mobility Division at MOLIT. Welcome. And we have Mr. John Yu, the Senior Representative for Asia Pacific at FAA, joining us today. Welcome. And moving on, I would like to invite to the stage Mr. Kim Jong-il, the Vice President of Global Solution UAM Business at SK Telecom. Let's welcome him with a big round of applause. And all right, let's invite Mr. Kang Seok-dae, the Deputy General Manager and Lawyer for the Korea Airports Corporation. Welcome. Yes, thank you very much, all the gentlemen, for joining us for the fourth session. And now I'm going to leave it up to our moderator, Ambassador Lee Jae-won, to lead the session.
Good morning. 자, 안녕하세요. I am
Good morning.
Council. I'm happy to see you today, and especially I have to see some young generation who are very interested in some aviation from the legal perspective. I'm so honored to moderate this issue to discuss new mobility, emerging but very critical issue for all today. Today we will share insight on opportunities and challenges in relation to the new mobility, such as UAM, AAM, IAM. I will use the terms interchangeably. I know that UAM is a subset of AAM, Advanced Air Mobility, IAM, Innovative Advanced Mobility, Air Mobility. Recent technological innovation of eVTOL, electric vertical takeoff and land, has made it possible for aircraft to fly without carbon emissions and with lowered noise. It really stimulates aviation interest for new mobility as innovative mode of transport for people and goods. At the same time, increasing demand for new mobility operations require a safe, secure, and efficient regulatory framework at the national, regional, and global levels. Major legal challenges we face today are about how to classify these new mode of aircraft, whether or how to integrate its aviation operations into non-segregated airspace and current aerodromes and ATM, and how to apply safety measures like airworthiness and personnel licensing. I hope today's discussion will help us understanding these legal challenges we face today. And I think the time is very limited. We are given some 100 minutes. So without further I want to direct some turn into our main issues. So today we have 4 presenters on this issue. Our first speaker is Mr. Choi Sung-wook, Director for Urban Air Mobility Division of MOLIT, Republic of Korea. He will share Korea's journey toward a new era within urban air mobility, UAM, and way forward. May I suggest welcome Mr. Choi with applause, and the floor is yours.
안녕하십니까. 방금 소개를
Yes, good morning. I'm Choi Sung-wook, director at MOLIT. First of all, I am very honored to be able to give this presentation at this event, this meaningful event. And I'm going to talk about what Korea is doing to prepare for the era of UAM. What kind of institutional and legal preparations are being made by Korea for UAM is the focus of my presentation. So I'll talk about UAM policy, our regulatory framework that's being developed, and I'll introduce UAM Team Korea, and then finally international cooperation. So first of all, KUAM policy. Now there are 3 big milestones that we have announced. The KUAM roadmap was announced in June 2020, and through that, we vowed to commercialize UAM by 2025. That's the goal. And there's going to be initial stage, growth stage, and maturity stage. So there have been 3 specific stages after the preparation phase that we'll go through. So we're currently in the preparation stage right now, which is identifying the issues, preparing the law standards, and doing the demonstration and testing. And then in March 2021, we came out with a technology roadmap. And you can see for each phase, 2025, 2030, 2035, there are different technologies that we need. You can see that. And the level of technology that Korea has and what we need ahead, and the R&D requirements and tasks ahead, all of that we were able to establish a plan for, and that's the technology roadmap. And then finally, the CONOPS we have developed in September 2021. CONOPS, the concept of operation, is in initial commercialization in the urban setting. We targeted that CONOPS for that scenario. And the R&Rs we also defined for the participants, and by each scenario, how the participants shall respond and their roles and so forth. We made that. So this CONOPS, to demonstrate this, we are doing a demonstration project around that. And the name of that project is the Grand Challenge. We call it the KUAM Grand Challenge. As you can see here, from last year, August, we started the Grand Challenge. And we're starting in a rural area that's isolated, not in the urban area. And then we're going to move that to the suburban area and then the urban core area. That's how we're going to do this in stages. So we call this stage 1 and stage 2 of the Grand Challenge. But the purpose of the Grand Challenge is various. But the first one is to look at KUM. This is a new mobility, and in the urban setting, can it be operated safely and stably? That's the first thing we want to demonstrate through the Grand Challenge. And the second purpose is to come up with the standards for KUAM. And third, there's a lot of private consortiums involved in KUAM, but their technologies have to be proven out. We need to see and prove out these technologies, and that's what we're going to do through the Grand Challenge. These are the consortiums or companies, 6 big consortiums. You can see the 6 boxes. These are the participants. You can see the players in the air sector, but construction companies, mobility companies, automobile companies, and so forth, telecommunications companies. There's a lot of participants in these consortiums. And so the Grand Challenge has started August last year. And so it's underway. The Grand Challenge program will be operated this way. The host is MOLIT, and CARI is the organizer. So CARI will be organizing the Grand Challenge, but the supporting organization is called UAM Team Korea. I'll introduce that later, but this is led by KAS. But look at the three players in the field. We have the operators, and then the air traffic management service providers, and then vertiport operators. These are the operators we need. And you can see the illustrations below. But these are the aircraft used by those in the consortium. And then you can see consortiums in the integrated platforms. Joby S4, which was certified earliest, is included as well. You can see a lot of different aircrafts that are included in the Grand Challenge. And there's additional aircraft manufacturers that are being included as we speak now into the Grand Challenge. Along with the Grand Challenge, we have a technology roadmap, and based on that, we have some R&D tasks that we are pursuing. And these are R&Ds that are done at the state level. So the first one is for 2025 commercialization. With the results of the Grand Challenge, we want to use the first R&D task with commercialization. So it's a virtual integrated operation platform program for UAM. And so the UAM program players can stably and safely operate UAM. That's the R&D that we're doing there. The second R&D task is in initial stage CNSI. We want to see if this can safely be operated. So that's a surveillance system for that. The first R&D task is by CARI and NASA. They have a grand challenge and a national campaign that they're doing, demonstration projects, and their data values and their results are being shared. So NASA also has a lot of interest in the first R&D task that we're doing. And the second R&D task, now I understand this to be the only one in the world of its kind, but the CNSI, we use 5G, and then we're preparing for 6G. So that's what we're doing. And then the third R&D task, we're going to start that this year, but the UAM 3 stages of development, I told you, but in the growth, after 2030, the growth stage, we need this vertiport certification and operation certification. So from 2024 to 2026, we will be doing this R&D task, the third one, that is. Now, let me talk about the regulatory framework, how we're developing the basis and the laws for KUAM. Now, we have established a separate UAM law, and in the US and Europe, they use existing aviation laws to regulate UAM, but Korea is going a different approach. We have made a separate UAM law, and there's two reasons for that. The first one is that current aviation regulations are too complex and stringent. So to develop something new, there's so many considerations that have to be put in. That's why we wanted to make bold regulatory exemptions so that we could quickly build an environment for UAM development. And also, because of lack of institutions, there could be some concerns and insecurities because investment decisions need to be made by the private sector. But if there's no guidelines given, then it's difficult for private investors to invest. So they requested the government to make some guidelines. That's why, from 2022, we proposed a bill. It was passed by the National Assembly last year in October. And so it was promulgated, and now it's waiting to come into effect this year. So first of all, in the UAM law, we define the concept because this is a new concept that was unheard of in the world before. So there's new terminologies that have to have legal status, from the definition of UAM itself, corridor, vertiport. Various things needed to be defined. Also, various stakeholders needed to be defined as well. And then vertiport development, how it's going to take place, the operator, what kind of system is going to be used for operation. All of that has to be defined. And the second is, after the definitions, it's the highlight of this law, but deregulation, basically. Because in Korea, we have the Aviation Safety Act, Aviation Security Act, the Aviation Business Act. We have 4 different aviation laws, actually. But we wanted to provide some kind of exceptions to the aviation law to the players in the UAM field. That's what we wanted to do, provide some exemptions so that an ecosystem can be built, basically. I'll talk more about that later. And then the last one is administrative support. We wanted to establish legal grounds for workforce development, international cooperation, financial support, and so forth to foster the creation of a UAM industry ecosystem. Now, very simply, if you look at some of the difference between the aviation law and UAM law, there's some new concepts developed. For instance, exclusive corridors have been established in the UAM law, and regarding security procedures, UAM aircraft and vertiports, there has to be simplified security procedures for that. And in the business concept, there's new UAM service providers like operators, traffic management providers, vertiport operators, so there's these new providers. And in terms of infrastructure as well, the public sector used to do a lot in the aviation sector, but now in UAM, we want the private sector to participate more actively to build that ecosystem themselves. And this is the new UAM regulatory framework, deregulation from aviation laws. You might misunderstand this because Korea is making a separate law for UAM. That might throw you off track, but we are not ignoring all of the aviation laws existing. No, that's not the case. Some people are concerned about that, but let me explain. The UAM, the essential safety standards we adhere to from the existing Aviation Safety Act, but we have a transportation committee, the National Transportation Committee, but for things that are not safety related, we wanted to deregulate. That's the first exception that we give to UAM operators and players. And the second thing about the UAM law is that in 2022, we proposed a bill, and this month it'll come into effect. But to change a system, Korea takes a long time. There's a lot of red tape, but we wanted to really simplify and facilitate UAM. So what the National Transportation Committee decided was once notification is given to the local governments and the players, then it's like a law has come into effect. That's what they wanted to say. So immediate decisions can be made. If the international standards or rules change to be harmonized with that, the Korean law needs to be changed quickly to adapt. And so that's why we're using these exemptions so that the UAM law can adapt quickly. That's another thing that we've introduced. So ICAO, FAA, EASA, all of these international rules and regulations, if there's an international standards that's established, we have a UAM law that can quickly adapt to that, so as necessary. So as a platform, this law is like a platform that can guide the development of the UAM ecosystem and industry while being very nimble to adjust to international standards. Now let me introduce the UAM Team Korea. We made the policy, the regulatory framework, but the government cannot do this alone. It's very difficult, and I know all of you agree with that. We need collaboration. That's why we have made UAM Team Korea. We call it UTK. About 160 organizations and groups are involved in UTK, and these are the players that are building the UAM ecosystem in Korea. You can see industry, academia, the central government, local governments, and then UAM-related organizations and research institutions are involved. So these are all the organizations that are contributing to making the UAM ecosystem, regulatory framework, and policy. This is UAM Team Korea. We have 5 divisions. So from the UAM Policy Division, Operating Division, and eVTOL, Infrastructure Division, Traffic Management Division, and Additional Services Division. And under that, we have like 2 or 3 working groups under that that will do working level work, and then we have supporting academia, research institutes as well to make specific rules and standards. So let me be more specific. In the working groups, they make something, and the division then deliberates on that, and then they submit that to the UAM Policy Division, and then the UAM Policy Division sends that down to other divisions so that there can be harmonization with the other divisions, and the opposite is possible too. For instance, the UAM Policy Division might be coordinating some kind of policy, but they send that down to the other divisions so that there's no conflict with the work that the other divisions are doing. If there is, then it's amended and made so that there's no discrepancies between the divisions in their work. So this is what I've been explaining. There's 3 working groups in the policy division, and then eVTOL and operations, 3 working. The infrastructure has 3 working groups. Traffic management 3. Additional services has 2 working groups. So each division has its own working groups, and they come up with their own regulations or rules that pertain to them. So that's the division of work we're doing, and each working group they draft these frameworks or regulatory instruments, and then it's harmonized. And another thing that's very important, besides our own work, we're having this seminar today, but international cooperation is very important. There's a lot of work being done by FAA and EASA as well, and trying to harmonize with these rules and regulations and trying to make international reasonable standards is very important. So that's why for us, international cooperation is also very important. Me presenting here is one of the proof that we find this very important. So with the FAA, we had a DOC last year, and we're working very hard with the FOA, and we have US FAA roundtables as well to share research and development results. And with EASA this year in March, but also through the APP program, we're also cooperating as well in UAM, mutual safety and technology. And with ICAO, we have a study group. Ka is doing that in the study group, leading that and supporting. But we're participating from last year, May, in the ICAO AM study group. And so also in the ICAO symposium, the MOLIT is also participating. So as we do our demonstration projects and the UTK activities, how we're developing all our things, we're going to present there in September. So with that, I'd like to conclude my presentation. Thank you very much.
Thank you so much for your comprehensive presentation. I think that it is very helpful for us to understand the basic policy and legal perspective, how we Korea looking for the future, the aviation, some world aviation policy. Especially, I think that the KUM Grand Challenge Program and recent adoption of UAM Act for Korea and composition of UN Team Korea is also very noteworthy for us to understand. I think that that will be very helpful for us to, the ICAO, prepare for AAM Symposium September in Montreal. To save time, we will have a Q&A session after all presentation will be done. And the next speaker is Mr. John Yu, Senior Representative for Asia Pacific, Federal Aviation Administration, FAA USA. He will deliver how FAA safely integrating advanced air mobility, AAM, into their national airspace system. And Mr. Yu, the floor is yours.
So there are a couple times in my life where I feel really nervous. I think the first might have been my first date with my wife. And then the second might be when I'm in a room full of lawyers who are not on my side, but on the other side. So it went well with my wife, who, by the way, is a lawyer. So I'm hoping by the end of my presentation and our discussion, it goes well here, and then we could all be really good partners going forward. So, 안녕하십니까? 나는 유요한입니다 from.
Hello, I am John Yu from FAA.
FAA's senior representative for aircraft certification, and I cover the Asia Pacific portfolio, and I'm based out of FAA's Singapore office. So today, I'm here to talk about advanced air mobility, or AAM, as we call it in the United States. AAM is basically, it's a term, and I want to level set it. It refers to a transportation system that moves people and cargo using aircraft with advanced technologies, including electric aircraft. So today I want to share a little bit about how the FAA is working with the aviation community, whether in the US or internationally, to responsibly and safely usher in this new era of aviation. The US has the most complex aviation transportation system in the world, and I think that we can learn a lot and share a lot of our lessons through some of our successes as well as our challenges as we continue to go down this path. I just hit this next button. Ah, there it goes. All right. So I just want to tell you a little story that kind of underpins this whole discussion. So when I first moved to Singapore, it was kind of at the tail end of COVID. So, people were masking up and people were very careful, coming out of a few years of a very difficult time in the globe. And I saw this boy going to school and he was riding a bicycle. He was wearing a mask, but he didn't have a helmet on. All right, so it kind of raises the question, what is the risk that he is mitigating, right? I think for 3 years, right, he's told mask up, stay away from COVID. But, he kind of forgot the lesson. If you fall off your bike, that's probably a little more dangerous in that situation, right? So I think that kind of underpins this whole exercise that we're all going through across all the member states as we work to enable AAM, is we have a lot of hard-earned lessons from our past history in aviation that have been, earned, through many serious accidents, safety incidents, and we need to remember those lessons from the past while safely balancing, allowing the innovation to occur and making sure that we're mitigating the right risk. I think that boy, that's something, he's reacting to what his environment showed him, right? The last few years, everyone tells you to wear a mask, you wear a mask, but you got to remember to put that helmet on as well. So collectively, we need to decide how we're going to handle risk across all of our countries so that we can enable these new technologies. And we have to find that right balance between innovation and safety. Should the AAM company's current plans play out, right now the FAA is positioning to issue our first AAM type certificate in 2025. Analysts currently predict that the market for AAM will grow to about $30 billion by the end of this decade. On the screen, you'll see some images of some of the partnerships that are occurring within this space across existing operators as well as new entrants into this AAM space. So they're working with established carriers, making sure that they learn their lessons as they operate and carry passengers for revenue or carry cargo, and trying to learn from all these lessons as they innovate and bring this disruptive technology. Their business models currently include transporting anywhere from 1 to 4 passengers between airports, central business districts, or cargo between small markets and different transportation hubs. And currently, while most operators plan to start with a piloted aircraft shuttling people and packages, they also envision shifting to autonomous operations, maybe even by the end of this decade as the technology continues to mature. This wave of innovation creates a tremendous demand on government resources, whether it's in the FAA or in other countries. And I want to share the FAA, we're trying to tackle that through a concerted effort that we call Innovate 2028. That requires us to take kind of a whole, all-of-government approach to addressing this. This is, as Mr. Che just presented, Korea is taking a similar approach, making sure they connect public-private partnerships, bringing industry, government, academia together to address this situation. This is happening in Japan as they're preparing for the Osaka Kansai World Expo next year as well. In the United States, we need to look not only at the federal safety and security aspects of this, but we also have to involve our local, state, and tribal governments because they have a significant part to play in the development of vertiports or other landing sites, as well as even the infrastructure that gets into charging, fire protection, security issues with police, and transportation networks in their communities. There's a lot to read on this slide, so I'm going to hit on a few things. This talks about some of our key enablers that the FAA is addressing to bring in this new technology into the national airspace system. First, we want to ensure that we're using maximum flexibility within the existing regulatory framework. In the United States, we feel that we can use the current aviation safety framework to enable these new technologies, and we use them through special conditions or exemptions that we can apply based on the designs and the operations that these companies are presenting. So to that end, we do realize that we do need to modify certain aspects of the framework and continue to evolve it. So we're approaching that with a staggered rhythm. So first, the FAA has designated our Office of NextGen to be our primary point of contact and focal point for AAM planning and portfolio management. In May of 2023, we issued 2.0 version of our UAM concept of operations, which provides a framework of operations based on anticipated levels of maturity in the space. And just in case it's not clear, UAM, we consider that a subset of AAM that focuses on operations in major metropolitan cities. In rulemaking, the FAA is currently working on a special federal aviation regulation, or an SFAR as you may have heard it, which proposes a temporary 10-year regulation to address powered lift aircraft operations. So we have a notice of proposed rulemaking that went out in the Federal Register in June of 2023. And we are currently dispositioning those comments, and we're currently on pace to release that rule by the end of this calendar year. What that temporary regulation allows us to do is continue to bring in public comment as well as engagement with industry in a very formal manner so that they can take ownership, take part of our regulatory rulemaking process. In July of 23, we released a broader plan called the AAM Implementation Plan, which guides the initial entry into service. And we are also currently working very closely with our Department of Defense and NASA on aircraft integration into airspace, as well as through White House-led working groups, interagency working groups, and industry working groups to conduct research on vertiports, as well as simulators and field testing to support the development of performance-based regulations. And lastly, our Office of Airports, in the fall of 22, they released an engineering brief 105, which contains interim design standards for vertiports. And these standards can be used to design new vertiports or modify existing helipads and airports to accommodate AAM aircraft. So this is just a starting point. There's a lot of work that goes in behind this, but this is our roadmap that we're going to continue to evolve as the technology, as the industry, as governments mature. I'm not going to get into too many of the specifics because I want to remember our time limit here, but I'm going to kind of, these slides will be distributed so you can start to read through, but I'm just going to take a look at some of the areas in a little bit more detail. So on aircraft, we're continuing to evolve our criteria as we learn about these designs. So you may have already seen we published our final airworthiness criteria for the Joby S4 recently, just a few weeks ago. That is going to be kind of the basis for our policy on how we're going to address aircraft going forward. And we're working on generalized airworthiness standards that will apply across other manufacturers as well. So when we have the generalized criteria, we'll apply special conditions depending on the different designs that they present. Powered lift, I talked about this earlier. I won't go into the detail again, but I think one interesting aspect, just so you know some of what we're looking at, in 1938, regulations have required dual controls for training of airplanes or aircraft, right? A lot of the new designs for AAM consist of single controls. There aren't any eVTOL pilots that are currently in the market right now, so that creates a unique challenge for us that we need to address. Do companies need to develop trainers with dual controls, or are there some other new and novel ways through simulation or other combinations that companies might be able to safely demonstrate that they can train the next generation of pilots and crews that are going to operate these aircraft? On the infrastructure front, the majority of manufacturers and operators right now, what they're planning to do is leverage the existing framework, right? So there are existing helipads, existing spaces in airports. So we're not looking at construction of vertiports just yet. Many of those design activities are well underway, so I don't want to make it seem like nothing's happening in that space. But the fastest route to entry into service was to leverage our existing framework, right? These are essentially kind of like air taxi helicopters in a way, just with different propulsion systems, redundancies, and different systems. So in many ways, it's not anything new, right? So the US has a lot of experience with air taxis. We call that our Part 130, they're regulated under our Part 135 framework. So this is just another type of vehicle that goes in, and we know how to handle those, and I would presume that other countries also know how to handle these types of operations, right? So in July 2010, our Office of Airports, they had a advisory circular, 150-5390-3, vertiport design. They canceled that advisory circular because they didn't know what the designs for these new AAM aircraft were going to look like. As an interim measure, in September 22, we released the Engineering Brief 105 for vertiport design. So they came up with some very prescriptive interim guidance based on the models that they knew at the time, you know, Joby, Archer, Beta, and then tailored some initial standards that we can use to start enabling this industry to form. The standards that are in this engineering brief are going to be specifications and practices that the FAA will recommend to ensure that we establish an acceptable level of safety, performance, and operation in the design of new civil vertiports, and to modify existing heliports and airplane landing facilities, right? So we're looking at things like passenger onloading, offloading, what charging is going to look like, how are you going to start routing passengers over to these vertiports, and the like. Innovate 28, I mentioned this before, this is just our umbrella term, so if you hear it, in the United States, we're looking at operationalizing AAM commercially by 2028. You know, I think we're going to have some demonstrations in between. The industry is going to continue to mature, but that is our target, to have regular commercial operations, be it cargo or passengers. The goals that we've defined are, we want to make sure that we have the safest and most efficient routes while we minimize the impact on our air traffic facilities as well as local area residents. We want to be responsive to industry plans for initial commercial operations. We want to develop a repeatable process, right? We want to be able to make sure that we can do this across communities. One of the major goals of AAM and the promises of AAM is that it can reach underserved populations, right? Communities that generally would have to drive hours out to an airport. You know, if we can shrink that in half or by, 80%, imagine the opportunities that creates in the aviation ecosystem. And then we want to make sure that we're building permanent, scalable, and repeatable processes and procedures and infrastructure so that we can support the continued growth of AAM operations. We're also looking, we developed an artificial intelligence roadmap to look at autonomy in AAM, and to that end, we have an autonomy working group as well. This chart's just an idea of some of the initial operations that are planned. You'll see they center around our major metropolitan areas, New York, Chicago, LA, San Francisco. You might also see Miami and Houma, Louisiana. So that one's interesting because that's looking at ship to shore. A lot of energy companies operate out in the Gulf. So these can do passenger cargo, from ship to shore. And I think that's a mission profile that might be something, I know in Southeast Asia, that's one of the areas that the companies are looking at as well. I am not going to read this slide. This is just for a takeaway, so this breaks down kind of all of the areas that we're looking at. You know, some that I didn't talk about, such as community engagement, cybersecurity, crew preparation. You can use this as a takeaway, and we're glad to answer questions after this. Most importantly, you know, international cooperation, especially in forums like this one, this is where, you know, we value tremendously because we hear from people in other countries. We get to learn what their concerns are and better tailor our operations and our approach. And I think basically international cooperation is the only way that we're going to make this a real reality going forward. We're working closely with ICAO. The FAA championed the creation of the AAM study working group. And then we have a number of bilateral, multilateral working groups. We're currently working very closely with our partners at EASA on a bilateral basis to look at and promote transferability of our products across borders, right? I think we want to make sure that we try to harmonize as much as possible, but the true goal is that we enable our products to be exported and imported across borders. Within Korea, Japan, we have declarations of cooperation, and we also have what we call an NAA network that we work with the UK, Canada, Australia, and New Zealand. And lastly, within this region as well, we have a APAC AAM working group. This is also a picture just domestically. I think Mr. Che also had a similar slide. These are a lot of our stakeholders that we work with domestically to make sure that we understand, you know, we're not, in the US you have a very strong federal system, but you also have very strong local governments, you have unions, you have other organizations, and the more that we bring them into the fold as we develop this, the more successful we'll be as a country. So lastly, to sum up, you know, I think there's a lot of excitement when it comes to AAM. You know, this is, when we go to forums like this or other conferences with aviation, this is always a topic nowadays, and I think it's because of that promise that's really exciting. Not only from what it could do for industry, but just the continued advancement even in safety, right? When you look at some of the systems compared to helicopters, there's a lot of safety advantages that AAM eVTOL machines can bring. Triple redundant systems, new and novel propulsion that promises to be more carbon neutral, and there's a lot of benefits that we can learn. So to wrap up, I just hope that sharing a little bit about the framework that we're approaching at the FAA in the United States can help inform some of the discussions that you have going on within your countries, within your organizations. And I just want to wrap up. I think there's, you know, on the moon, after Apollo 11, there was a plaque that was left up by Neil Armstrong and Buzz Aldrin, right? And that plaque says, "We came in peace for all mankind." So I hope that you can take some of this and go in peace and use this to the benefit of your countries. So thank you.
Thanks so much, Mr. Yu, for your very comprehensive but compact presentation of U.S. effort to set up the new framework for AAM in your country. I found that U.S. has really taken painstaking effort to set up the legal framework. And in the name of FFA Innovate 28 program, I found how the government has tried to prepare for some AM operations in a more whole of government approach to address this issue. Thank you again for your very comprehensive presentation today. Our next speaker is Mr. Jung-il Kim, Vice President of Global Solution UAM Business, SK Telecom. He will present the new mobility market players' perspective on legal and regulatory framework.
Yeah, hello. My name is Jung-il Kim, and I'm tasked with UAM business at SK Telecom. And it's a great honor to meet everyone in this ICAO legal seminar. It has been more than 5 years SK Telecom has been preparing for UAM business in Korea. As a result, We are now positioning ourselves as one of the most active companies to lead the whole industry, not only in Korea, but also globally. In this session, I'm very pleased to introduce SK Telecom UAM business plan and legal perspective. Before diving deep, I first introduce SK Group and SK Telecom. SK Group is the second largest conglomerate in Korea, which has a strong presence in the ICT and energy and semiconductor sector globally. SK Telecom plays a role as a ICT arm for SK Group and the #1 telecommunication company in Korea, along with the most advanced AI technology and telecommunication technology. Then, on this slide, do you notice what the items you see on this slide have in common? In fact, just 10 or 15 years ago, all of these technologies are considered unfeasible in the aviation industry. But thanks to various technology development we've had throughout the last decade, the aviation industry is being proliferated with eco-friendly technology and innovation. With this wave, many international organizations and countries are trying their best to conduct meaningful demonstration and trials that lead to actual commercialization of these technologies. UAM or eVTOL are one of those innovations, and eVTOL stand for electric vertical takeoff and landing aircraft is steadily being developed thanks to its outstanding characteristics, such as a low noise and eco-friendliness. It means zero carbon emission and safety and the low altitude flight, along with the battery capacity and technology development. And then it's on the verge of commercialization. Then, what is UAM? UAM stands for Urban Air Mobility, and it's also known as Advanced Air Mobility, AAM, or Regional Air Mobility, RAM, or Innovative Air Mobility, IAM, as other speakers explained. It's very new type, and it's a novel transportation that carries passenger and cargo over the urban area. Globally, we are expecting the UAM to be the game changer as a cutting-edge solution for traffic congestion and pollution in the metropolitan city. More importantly, through the use of electric-powered eVTOL, which allows, as I said, zero emission and capability of vertically takeoff landing. Then, even though I emphasize the importance of eVTOL in UAM business, but the UAM as a whole should be understood in a broader perspective. As you can see on the slide, UAM is not just focused on the eVTOL aircraft. It's a huge industry that consists of so many stakeholders, as you on this slide. First of all, there must be on the OEM, the aircraft manufacturer. One thing to note is that the OEM should not only manufacture, but also prepare for maintaining the airworthiness of the aircraft, as well as training of personnel like a pilot. Joby Aviation and Aurora Supernova, Aurora Archer, and so on could be examples of manufacturer. Next, as we cannot pilot the eVTOL by ourselves, we also need a service provider, such as the air carrier, who provides service operation as well as traffic management for safely operating the aircraft. Then we need massive infrastructure like a vertiport, which serve as an airport for eVTOL aircraft. So it can successfully take off and land vertically. One big difference between vertiport and existing helipad is that vertiport needs to be equipped with the electric charging infrastructure for the aircraft. I see a lot of government officials here. So what are the government bodies' role, assuming that these three parts previously introduced are done by private sector? As an emerging industry, how the regulation are shaped in UAM is a crucial part for success. We expect the regulatory bodies to be preparing for a holistic legislation and guideline for business right, permission for route or vertiport, specialized law, and criteria or processes on qualification and certification. In a local business perspective, SK Telecom also has keen interest on cooperation with local government. Local government will play important role in developing specialized routes or authorizing vertiport or routes, factoring in local characteristics and communities. At this point, many of you might have a question. As I explained about SK Telecom is a telecommunication company. Then why is it drilling a UAM business or aviation business? SK Telecom have the goal to transform our fundamental business or identity into AI leading company, utilizing our cutting-edge AI technology and the digital infrastructure. Our business strategy could be found in AI pyramid, as you can see on this slide. And AI pyramid consists of AI infra, the bottom line, and the AIX means AI transformation, and the top is AI service. AIX is a concept that applies AI technology into new business, new industry, such as UAM and healthcare, and expand AI technology into the existing telecommunication business area. The UAM belongs to the AIX sector, and as a part of this, we are trying to transform our identity into the advanced mobility company powered by AI technology. So we, SK Telecom, see UAM business as the paramount growth engine of this. Particularly, we are preparing for UAM service that supports various functions such as ATS bus and vertiport as well as flight operation. SKT and Joby Aviation, the global number one eVTOL OEM, has developed a strong partnership preparing for the whole industry and value chain since the first strategic collaboration agreement signing in early 2022. And we believe that this performance you can see on the slide will make Joby to be the first one passing the FAA type certification process. At the previous session, the Director Mollet already explained the grand challenge. I'm able to move on to the next slide. And the partnership with the local government. Since the SK Telecom is known as the fastest company to start the UAM business in Korea, we got lots of love call from local government. Each local government has started discussion with the SK Telecom. Especially 8 regions marked in green have signed the MOU with our consortium for commercialization. Not only signing for MOU, but we are also studying on each region's environmental characteristic and is preparing for specialized routes to fit each region. Then let's deep dive into the legal perspective. Although not a legal expert, we have had a valuable opportunity to look into related standards and regulations, and have discovered some legal trends as well as the impact of international standards and the country-specific regulation on the industry. Also, before conveying my opinion on legal perspective, let's go through major countries' policies, including Korea. But the director of Morley explained the Korean policy in detail before. I'm able to skip this slide. Not only Korea, but also USA and Europe and other countries are competitively introducing policies and actively supporting the technology development in UN business. Each country is proposing new regulation and the roadmap to suit its uniquely applied environment and the legislative process. While there are differences in nation policies, the current trend in UN regulation is that they are in line with the existing aviation system. Some countries can come up with an innovative solution, but we can notice that being incorporated into the existing system is important due to the fact that the aviation industry is largely based on the internationally accepted standard. Speaking of international standard, the biggest reason why the national regulations in the aviation industry are similar to each other is because they tend to comply with ICAO's international standard. Information exchange and compliance across the border is an important concept in the aviation industry. Since even a single deviation might result in a safety risk, thus it is important for all the contracting states to abide by international standards. As such, the UN's regulatory framework is also closely related to ICAO's SOPs, areas that are particularly dependent on the SOPs are qualification, flight rules, operation, airworthiness, communication, ATC, and aviation information. The dependency means that when the SOPs is revised, the UAM industry will also inevitably be affected by the revision. When dealing with the enactment and the revision of standards, it is necessary to examine in a holistic approach. Of course, the regulation should value safety on top of any value. However, we insist that authorities also take into consideration the intertwined interest of industry as well as look for ways to not harm the revitalization of industry. In particular, the UAM field requires more holistic review by consulting closely with the local government and industry. Additionally, the international level regulation and the national level regulations should be dealt differently when enacting or revising them. This and the next slide shows some consideration from an industry perspective. First, amendments to international regulations such as ICAO's SOPs should keep the following items in mind. First of all, there exists an asymmetry, the level of information obtained between countries. The industrial development of each country is obviously different, and the level of participation as well as the possibility of participating in ICAO's committee or panel activities result in the different level of information country can get following the regulatory changes. Another consideration is that different countries have a different legal system and characteristic. Countries with hard legal system, unlike a soft legal system, require significant amount of time for reviewing or adopting a new change. There must be sufficient notice in advance for this case. Finally, since the adoption of international standards has a profound impact on the industry as a whole, sufficient communication with various stakeholders and quantitative review of the impact of regulation should be done in advance to minimize negative impact. We understand the critical importance of international standard in the UAM industry and ask for those who participate in an international legislative process to carefully examine the national level and the industry level impact of international regulation. SKT is also always happy to discuss the diverse approach we can collectively take to enlarge the positive impact of international standards while minimizing the negative impact on industry. On a more domestic level, legislators in countries that accept the international organization or enact new national regulations should also carefully examine the impact of policies. One way is to conduct a quantitative analysis of regulatory impact in advance, and then qualitatively discussing with the industry stakeholders. After introducing the regulation, it will also be important to constantly check the quantitative result, whether the regulation is actually functioning as it intended. It's not that regulation should always be alleviated. In an emerging industry, number one value of safety should never be harmed, which means in some areas such as UAM, the regulation needs to be strengthened. It is yet hard to guarantee the complete safety of the new aircraft, so it is necessary to take a closer look into the certification operation of the new aircraft. Of course, in the future, when sufficient data and verification are obtained, we will have to move toward easing the regulation. In addition, efforts should be made to increase public acceptance so that the public does not fear or reject the new type of aircraft, and so that there is a room for the industry to utilize a public infrastructure or a public project when revitalizing new business. Although not a long story, we have found out different perspectives toward the UN policy and regulations in the past few years. As a leading company in Korea, UM industry, SK Telecom will not only try to proliferate industry, but also look for ways to continue the business without harming safety as our top priority. We will constantly look for ways to contribute to the country and the industry as a whole. UAM may still be a long way off, but will definitely bring about so many international and national paradigm shift. I hope that the public and the private work together to positively shape the standard and the regulation so the industry can take part in stably promoting their business. Thank you.
Thank you so much, Mr. Kim, for your giving us a good chance of some hearing from the private sector's perspective on how to address this issue, and also you highlight the significance attached to the partnership with the local government, and also UM business value chain is also very noteworthy for understanding the UM ecosystem afterward. Our last speaker for this session is Mr. Seok-dae Kang. He is now Deputy General Manager lawyer from Korea Airports Corporation. He will give us presentation on legal mind on airspace integration, adoption, change, and what we should do. So may I suggest welcome him with some applause. Mr. Kang is here.
Thank you. Yeah, I'm Dr. Kang. I work for Korea Airports Corporation as a legal attorney. I'm so excited to speak in front of many air industry leaders and experts. I really hope my presentation will be helpful for you to raise your understanding and awareness of new air mobilities and airspace integration. Okay, before getting into the presentation, I would like to briefly say what I'm going to talk about today. First, I will introduce some new air mobilities like UAM or UA, and then I will explain what is airspace integration and why it is needed, and the possible legal issues arising from airspace integration. And last, I will just cover what ICAO should do for airspace integration. Okay, let's get started. Now we are seeing the advent of new air mobilities, like UAM and AAM. But when you think of new air mobilities, what comes to mind? Probably, is it safe? Yes, right. So, according to the EASA study, people's most concerns about new air mobility are safety. Whatever new air mobility is, there are three crucial factors to consist of that. The first thing is the aircraft itself, like eVTOLs of UAM. The second thing is ground part, like F-44 of UAM. The last is aviation. All these things are important, but I would like to give priority to aviation because it is directly related to safety. And I think the airspace integration will be the first step to deal with this safety matter. And what is airspace integration? Unfortunately, there's no definition in the official legal, international law and guidelines. But we can draw the meaning from many texts. Airspace integration means when a new air mobility is introduced to airspace, to make sure that it can operate safely under the existing airspace management system. And usually it entails three things, like our minimal additional infrastructure and minimal additional burden to airspace users and operation under current airspace regulation. So what's the best way to approach airspace integration, and what's the best way of accomplishing airspace integration? I would like to suggest three ways for airspace integration. The first thing is to drive and analyze possible legal issues arising from the operation concept of new air mobility. It can give some feedback to current operation concept, and finally, it will contribute to evolution of the current operation concept. And the second thing is to apply the new air mobility concept to the domestic laws. Because, airspace integration will be eventually accomplished by regulating domestic laws. And the last thing is creating global model norms applicable to each state's airspace law system. I think this is the job of ICAO. Okay. And now I will tell you how airspace integration is implemented in UAM concept. This UAM concept is based on FAA UAM concept version 2. Yes. Let's look at how airspace integration is implemented to UAM concept. It consists of segregation, adaptation, and change. It put altitude scope from 1 to 2,000 feet, and it established a UAM corridor to disrupt to prevent disruption. And it is subject to the rules of airspace classification, Class B, C, D, or E, and it needs some evolution of a regulatory framework for UAM airspace management. Yeah, and the UAM concept, established one unique way of airspace management. Yeah, it's called UAM cooperative environment because, the airspace management is conducted by a cooperative service of UAM participants based on information and data sharing like PSU or PIC. Yeah, and in more detail, yes, in UAM corridor, ATC doesn't control any doesn't provide any air traffic management. In UAM corridors, yes, the airspace management, air traffic management is conducted by a cooperative management, by PIC or PSU. And now let's get into legal issues. The first legal issue is who controls UAM operation. I think it's very easy. Yeah, probably, the UAM pilot. But I mean, in UAM corridors, many UAM operations, happen simultaneously. Who controls UAM operations? Yeah, as I said, in UAM corridor, ATIS does not provide air traffic service, such as a separation. So PSU just provides its UAM operator with information about other UAM operations in corridor. And UAM operators also support cooperative separation management. But there's no entity to control UAM operations directly. But do you think this cooperative management can ensure the safe operation of UAM? I think this should be more verified through constant and repetitive verification and practices. The second legal issue is aircraft entering corridors in uncontrolled airspace. Yeah, in controlled airspace, ATC ensures separation of non-participating aircraft from the cooperative area, like UAM corridor. But what if aircraft through UAM corridors in uncontrolled airspace? Yeah, UAM pilots can be offered information from PSU about other UAM's operation based on flight intent. But small aircraft usually do not have those equipment to exchange information. I think there needs for plans for this kind of possible contingencies in uncontrolled airspace. Now, just let's look at the UAM operation in controlled airspace. As I mentioned, in controlled airspace, ATC controls the movement of all aircraft, but in UAM corridor, ATC does not directly provide air traffic service to UAM pilots. And what if the UAM corridors are located in controlled airspace like Class B, C, or D? Yeah, according to the concept, UAM concept, the section controlled by ATC, the ATC controls UAM operation from departure to UAM corridor, and from UAM corridor to arrival. Within the UAM corridor is controlled by PSU or UAM operator. But considering the class, considering the safety of UAM, it's not easy to convert control from ATC to PSU like that. And the Class B is the biggest airspace. So considering the kind of things, the section from bodyfloor to corridor and vice versa should be minimalized. And now I'm going to talk about the legal issues arising from between UAM and UA. Yeah, the airspace of UAM UA is basically separated by altitudes. So actually, it's not likely for UAM and UA just to face each other. But when some abnormal situations happen to UAS, UA may enter UAM corridor, especially in uncontrolled airspace. According to UAM and the UTM architecture, there's no direct channels to communicate with each other and to share information and data. So I think that direct ways to change data between PSU and USS should be made. Okay, the less legal issues about the unmanned aircraft that can be used for UAM. Yeah, according to UTM CONOPS 1 point, it limits UA to small UAs under 55 pounds, but there's no limit weight in US CONOPS 2 point. So unmanned eVTOL can be subject to the architecture of UTM CONOPS 2 point, but it does not conceive transportation of persons. So I think it will be included in the evolved UAM CONOPS, maybe next CONOPS. So from now, I'm just going to talk about how the operation concept, how applied to UL mobility operation concept to the current existing laws. Yeah, I'm going to call this process, airspace law integration. Yeah. Usually, there are two ways to accept new air mobility operation. So one is to change some respective parts of each air law. The other is to enact a special act. Yeah, it depends on each state's air law system and legislative policy and tradition. But both ways can be used complementarily. And now I'm going to tell you how UAM concept is applied to Korean air law systems. Basically, Korean air law system consists of four main air-related acts: Aviation Safety Act, Aviation Business Act, Airport Facility Act, Aviation Security Act. The Korean government also selected a way of creating special act to accept the new air mobility. However, if both special acts do not cover the whole essential parts of the operation, the four main acts also need to be amended on some relevant parts. Let's look at airspace law integration about establishing UAM corridor. The UAM Special Act empowers the Minister of Land Transport to establish UAM corridor on the airspace of the area operated for a UAM operation. However, there are no detailed regulations on procedures of establishing UAM corridor. Yeah, basically the matters related to the establishing and managing airspace are stipulated in the Aviation Safety Act, and I think it's important to apply and interpret the acts so that both do not conflict with each other. Yeah, look at this. This is the table of classification of airspace in Korean air law. Look at the warnings airspace. Yeah, you see the ultralight vehicle flight areas. What is ultralight vehicle? Yeah, actually, yeah, Korean air law system has a unique thing about the aircraft classification. Yeah, it classifies the aircraft by weight. So in terms of unmanned aircraft, if it is more than 150 kilograms, it's unmanned aircraft. But it's under 150 kilograms. It's not unmanned aircraft. It's just ultralight vehicle. But anyway, if a UAM corridor is going to be set on some airspace, probably the Korean government will put the special use of airspace, like UAM flight areas. Yes. Now let's look at establishing PSUs in Korean airspace, Korean air law system. The UAM Special Act empowers the Ministry of Transport to designate PSU, but yeah, there are no detailed regulations on procedures of designating PSU. Yes, basically the matters related to air business are stipulated in Aviation Safety Act, and the air traffic services are subject to Aviation Safety Act. It is essential to establish the procedures on sharing information and data between ATC and PSU. And what's the role of ICAO? Yeah, the advent of new air mobility is essentially followed by new norms regulating related legal issues. Advanced air industry stage will be leading countries in creating new procedures and rules through constant and repetitive verification. Those procedures are rules, or those procedures and rules will be evaluated through legal researches, and those evaluations will lead to the creation of global model norms. Yeah, ICAO should create global model norms to be applicable to the states introducing new air mobility. So now, what should we do? What should we do? So, yeah, I think as legal experts about air law, yeah, I would like to finish my presentation with the following sentence. Yeah, this sentence is actually, yeah, the closing remarks of my thesis of master degree in McGill about UAM and drone laws. Yeah, the air and space law is like a large organism influencing each other, and progress promotes another progress. This is why I'm convinced that the research on Korean drone laws and UAM laws will help develop other countries' legislation and ICAO's model regulation. For the development of drone and UAM laws, this process will have to continue under each state's legal regime. Okay, thank you.
Thank you, Mr. Kang. You raised the very difficult legal issues when we integrate the UAM into some non-segregated airspace later, and some. Are you following the current president today? So I think that it is more complicated, technical than we expected today. So currently, I found that we have 20 minutes to a discussion on this issue. And first, I want to give one or two questions to these speakers, and I'll open the floor for your question. First one is, it goes to the two speakers, Director Choi and Mr. Joan Yu. I found that according to UAM survey by EASA, European Union Aviation Safety Agency in 2021, overall perception of UAM is positive, with 83% of respondents having a very or rather positive attitude, some utilizing UAM service afterwards. And at the same time, many respondents consider emergency use cases not for transportation of people for the time being as most useful for society. I found that one of their main concerns is safety. As you might understand, that without safety, it's not easy for us to see the future situation, how we see some UAM flying over our head. So I think a policy or a rule maker has a really tall order of ensuring safety as a priority, at the same time building a new mobility ecosystem, because the industry is very initial stage and nascent. So my question goes to, how can we address safety? How to classify powered lift like electric vertical takeoff of land as an aircraft? How about requirement for airworthiness and personal licensing? So can you answer my question for two speakers, one Director Choi and Mr. Yu? Who will give first? Mr. Yu?
Yes, that was a very difficult question, actually. And you talked about the UAM survey, but in Korea as well, to get public acceptance, we're looking at convenience, safety, Three aspects, like safety is the most important among these issues. So if we don't have safety, then public acceptance cannot be achieved. That's what we believe as policymakers. There were other presenters after me that talked about the aircraft airworthiness, also about airspace integration and safety. Whoever does that, PSU, how to do that, airspace safety and also ground safety as well. All of that, it's things that we need to consider. But unfortunately, the aircraft manufacturers are doing their work overseas, really, these OEMs. So you saw the HKT talking about their presentation for the aircraft safety and certifications. We're trying to do that together with the FAA. And regarding operation in the skies and on the ground, I talked about the grand challenge that we're doing, this demonstration project, but we are doing all the scenarios, proving out all the scenarios, the emergency situations as well. And only when that is confident, when we're confident about that, we will launch this service. We're starting with the rural, the suburban areas, and then the urban areas. That's the 3 steps that we're going to take in the grand challenge. And each step, we have these safety rules that need to be complied with. Once we prove out these safety features and the safety effectiveness, then we move on to the next stage and continue. That's how we're going to do this Grand Challenge demonstration project. So regarding aircraft safety, the mechanical aircraft safety, maybe you can talk more about that.
Give us more further information on that.
Sure. I think, I think it's really kind of a fundamental question of, how does society accept new technologies, right? At the end of the day, we're talking about an aircraft, we're talking about new innovations. We have new innovations in aviation going way back, right? 1980s, we were using 3D printed parts in aircraft. This is something that, we deal with as an industry, as regulators, since this industry started. So I think that comes about from how are we going to be transparent about all of the work that's going on? How are we transparent about what these new technologies mean? What's happening within the aircraft? How are we handling, the crew training requirements, maintenance requirements, and as well as the associated infrastructure. So I think I want to be careful. A lot of times right now it's very easy to focus kind of on the aircraft aspects of it and looking at it from airworthiness standards and saying what is, we have debates all the time. What is the right safety target? When we come at it from a probabilistic method of safety analysis. I think I'm not discounting the importance of it, but you have to look at it with respect to the entire ecosystem, right? Because everything is layers of safety. And then for the flying public, it's understanding what that looks like, right? Because they're going to start looking at how they view aviation right now, and then they're going to say, how is this different? How do I incorporate this into my life? And how is this going to impact me? And then I think we got to try to make sure that we're, working together to really make sure everyone understands the activities going on. So.
Okay, because I don't have enough time, so I want to floor the open. Anybody who want to ask a question? So in that case, raise your hand. Nobody want to take the floor? So in that case, on your behalf, I want to ask a question again to our speakers. My second question is, I know that ICAO is also doing its part with regard to the UAM. And I found that ICAO revised Annex 1 on personal licensing to cover power lift as new kind of aircraft in 2006. And Mr. Chan already mentioned, and last year ICAO established the Advanced Air Mobility Study Group, AAMSG. And also, at the same time, ICAO will hold its first AAM symposium in Montreal this September. So In this context, which role do you expect ICAO to play in addressing new air mobility in the future? And what input do you want to put this coming ICAO symposium? So may I ask you this question to Mr. Jung-il Kim and Mr. Sok-tae Kang first?
Before I answer the question, I beg your understanding for speaking in Korea in order to convey my opinion exactly to you. Yeah. 제가 발표.
So, like I said in my presentation, ICAO in the aviation industry has international standards. They establish the international standards. That's their the ICAO body does that. And UAM, the industry itself right now is not even born yet. It's preparation stage. But the concepts, the ConOps, and the operation systems need to be defined and developed. But UAM is also part of the aviation industry, is how I look at it. So UAM internationally, it's not international transport, but within a nation, it is within one state, this aircraft will be moving. That's how we're preparing it now. But the ICAO standards we have to look at nonetheless, I think, in building standards for UAM. So ICAO has to have regulation standards for UAM, make it specific, speed up a little bit on your UAM efforts is what I like to ask ICAO, because for each country, they will have their own specific circumstances, and based on that, they make their own policies. But later on, this has to converge, and it will converge into ICAO standards, I believe. So the regulatory framework and the legal basis and all of that, if it takes too long, there's going to be a lot of trial and errors when this converges. So ICAO has to work more quickly, I think, on UAM standards. They have to speed up. That's what I think. So that each respective nation or country and the players within that nation can easily prepare for the UAM era.
Yes. I think the final goal of ICAO is to create new model norms to be applicable to each state. Yeah, but before that, I think the ICAO should participate in from the verification stage of each state, because I think that's the first step to create new norms, model norms. Because ICAO can collect and analyze some pros and cons from the each stage verification and each stage status. Yeah, I think it's the first thing for ICAO should do.
Still, thank you so much for your answer. And still, we have some 7 to 10 minutes. So, anybody who want to ask a question? Yeah, I found the person.
Yeah, 안녕하십니까.
Hello, I'm from Seoul Regional Airport Corporation. I'm Oh Sung-hwan. Thank you very much for your presentations. And while listening to your presentations, I had one question. So I want to ask questions to four of the speakers. So I want to know why we must make up the PSU, because Mr. Kang explained in his presentation that we have to take a look at the issues between the ATC and PSU, and then the roles of the PSU can be maybe done by the ATC under the MOLIT as existing system. So I was wondering, why do we have to make this PSU operator newly? Because I believe that it has more like public purpose. So that's why I'm asking you this question.
Thank you so much. I think that Mr. Choi you can respond. for such question.
우선 질문 감사드리고요.
First of all, thank you very much for that question. In the beginning of commercialization, we also are concerned about the role of PSU because the public sector should manage and control, right? That's what we've been doing. But ultimately, the UAM ultimate goal, if I can put it that way, if you imagine that, then PSU is necessary, I think. For instance, until now, in legacy aviation, the number of players and the number of aircraft in the sky relatively compared to UAM ultimate goal is small. That's what I believe. So at the ultimate picture, the private sector should be able to do on-demand services, and I don't think the state can control all of that. That's my question mark. That's why PSU, I think, is necessary. So if I summarize again, in the beginning, as you understand well, through an exclusive corridor, UAM will be operating, and we provide surveillance, monitor, and then when we get to dynamic corridor, then the public systems and information the public can provide, but the private sector, within what the frame that the public sector has made, they should be able to do it freely according to market principles. And operate the system. That's what we believe. That's why the government has introduced a PSU concept. But in the initial commercialization, you might not notice this, though. But in the roadmap that we have established in the second stage, in the growth stage, this issue, I think, not only Korean domestic, but overseas as well, there will be challenges around this. And whether it's necessary or not, like the person that asked the question mentioned, I think there's going to be debate about it perhaps down the road. But right now, in our roadmap, we do have PSU in mind. It's there. And our CONOPS also considers PSU, and the Grand Challenge is also considering that. So that's why there's PSU roles specifically. But in the beginning, initially, the role will be little. But when we arrive at the mature stage of UAM, then I do believe PSU would be necessary. I don't know if I answered your question well, but that's my answer.
So can you respond to his question?
Yeah, I'm not sure if I fully understand it in the correct context, but I think you're hitting on kind of the debate that's going on. You know, even in the United States, when we're looking at vertiports, you know, we're questioning what is the role of, you know, do we have temporary exclusive agreements for certain, you know, vertiport operators, or do we leave it as kind of like a public good and you know, take away sort of that kind of exclusivity. And I think really it comes down to is it depends, right? You know, I think every state, and I use that in the US, right? Even in different states within localities in the United States, we're gonna have different considerations, right? I think the most important thing, and maybe this goes back to the question about ICAO's involvement, is, you know, regulation you have to be very careful with regulation. My colleague here, I'm not contradicting. I think if I think about the movie Fast and Furious, you know, there's a line, you know, smooth is slow and slow is fast, or slow is smooth and smooth is fast, right? I think we have to be very careful before we regulate too stringently, that we understand, you know, how is this industry going to evolve first, and make sure that we're applying attention at the right places, and at other places allowing industry to innovate and go as fast as they can go, right? And I think that's the balance that every country is going to kind of have to decide on their own.
Mr. Kim, do you want? Perhaps?
네,
Yes, about the role of PSU, there's a lot of opinions that could be possible. And this is just personally my own personal opinion. But UAM in the aviation industry, I told you it's part of the aviation industry, but if you look at the characteristics of UAM, whether it's transport or mobility, we have to look at it that way. Existing aviation, you have airport to airport. It's transport. It's a concept of transport from airport to airport. But UAM is more mobility. It's in the air. Of course, it's aviation because it's in the air. But the mobility characteristic is that there's no point that's designated, let's say. So the people that use this can move from the point that they want to a random point that they choose. So that's why it's mobility. And UAM, the ultimate goal, like Mr. Che said, it's going to be highly dense. Whether it's a dynamic corridor or a fixed corridor, or it's going to be very dense. There's going to be a lot of aircraft there. Can ATC cover all of that? You have to think about it. And so that's why there's the concept of PSU. But in the beginning of commercialization, will we need PSU? I don't know. That's something that we have to review. Maybe in the early stages, you don't need it. But in a more mid-long term, when we get to high density levels, we need that. That's what we're talking about. But in the initial commercialization stage, it's only a few aircraft that will be in operation. So whether PSU is needed immediately, that's something we can think about. But ultimately, we will need PSU. And we do need to test it out in the early stages for that later stage. That's what I think. Okay, so that's what I want to say.
Go ahead.
Yeah, I think they are creating PSUs because of one principle of a UM operation concept. Yeah, as I said, it just minimalizes the burden to existing air traffic controller. But as I mentioned, nobody knows it can guarantee the safety of UAM. So I think the more it should be more verified, more tested through constant tests and practices. So because nobody knows now. Yeah.
Okay, thanks so much. Any further who want to ask any question? If not, I want to conclude our session on new mobility. Thank you much, everyone, and for speakers for your good presentation and the attention for this session. I really hope that our discussion today could provide some insightful, for any state or any other institution who want to plan or implement a new mobility-related innovation into existing aviation system in a more effective, safety manner. And also, I hope that our discussion today provide a real good input to the ICAO AM Symposium in September in Montreal. Thank you for your attention today. Thank you.
Yes, thank you very much. We're going to end the fourth session here, and the gentlemen can all go back to their seats. Yes, this session led by Ambassador Lee as well as the 4 other speakers, we were able to look into the new mobility, aviation, as well as the legal perspectives. I guess this was also a new thing that is going to be talked more often in the future. And now we're going to move on to the luncheon, for the day 2 in 2024 ICAO Legal Seminar. The luncheon is going to be hosted by Korea Airports Corporation, which currently operates 14 airports in Korea, including Gimpo, Gimhae, and also the Jeju airports. For you to get familiar with this Korea Airports Corporation, we have prepared a short clip for you. So let's pay attention to the screen. Welcome back, everyone. Let's energetically start the 5th session here at 2024 ICAO Legal Seminar. The 5th session is going to dwell upon the current issues in aviation law and practice. And this session is going to be led by Ms. Siu Hui Tan, who is the Director of Civil Aviation of Singapore and also the Chair of ICAO Legal Seminar. Let's welcome her to the stage with a big round of applause. And for this session, we're going to be joined by 2 distinguished speakers. First of all, let's welcome Mr. Yao Nampong, the legal officer from the Legal Affairs and External Relations Bureau at ICAO. Welcome. Let's bring on to the stage Mr. Lee Keun-young, the president of the Korean Society of Air and Space Law and Policy. Let's welcome him with a big round of applause. Yes, now I'm going to leave it up to our moderator to lead the session.
Thank you very much. 안녕하세요. Good afternoon, distinguished ladies and gentlemen. First of all, I would like to thank ICAO, and in particular Mr. Michael Gill, and the government of the Republic of Korea, especially Minister Park, for inviting me to participate in the seminar as a moderator for this session. This session on the current issues in aviation law and practice will cover two major matters. First, updating the rules for the settlement of differences under the Chicago Convention, to be presented by Dr. Yao Nyampong. And the second, how the Chicago Convention has worked for the last 80 years. We have up to 3:30 p.m. for this session, about 1.5 hours. The first presentation will cover the work of the working group for the review of the rules of the ICAO rules for the settlement of differences, also known as WG-RRSD. This working group, established by the ICAO Legal Committee in 2019, owes much to Dr. Yao Nyampong's contribution and support as a member of the ICAO Secretariat team. The Legal Committee will deliberate on the working group's proposed revisions to the ICAO rules at its upcoming 39th session this June. Dr. Nyampong's presentation will assist states to prepare for this priority work item of the ICAO Legal Committee. Dr. Nyampong is a legal officer in the ICAO Legal Affairs and External Relations Bureau. Prior to joining ICAO in 2016, he served as a senior legal officer with the African Union Commission. His areas of specialization include air and space law, public and private international law, international administrative law, commercial law, and dispute settlement. He is given the greater amount of time for presenting in this panel. And questions and answers can be addressed to him immediately after his presentation. And the reason is because the two topics are kind of different. And after that, I will introduce Professor Lee for his presentation, but it will be preceded by a rather long introduction on my part, and I will explain when we come to it. So Dr. Nyampong, please. Thank you.
Good afternoon, everyone. Let me begin by expressing gratitude to the Ministry of Land, Infrastructure and Transport for the invitation to participate in this seminar and for the warm welcome and the warm reception that you have given to us during our stay in Korea. This is my second time here, and it gets better every time, so thank you. I will be addressing in the next few minutes the work that has been done by the working group for the review of the ICAO rules for the settlement of differences. This, as the moderator indicated, is a working group of the legal committee of ICAO, which was established specifically to review the ICAO rules for settlement of differences. Of course, in an ideal world, we would hope that there are no disputes between states, right? But we do not live in an ideal world. And so, despite our best intentions, disputes do arise between states. And so there is a need for mechanisms or a mechanism to address those disputes, particularly those pertaining to the interpretation and application of the Chicago Convention, which I'm sure you've heard so much about in the last few hours. So I will, in traditional aviation format, pretend to file a flight plan for this flight, which you see on the screen. Unless there are, severe objections to this flight plan, I will consider that it has been approved, and we will start our takeoff roll, and hopefully we will land when we get to the next steps. Okay, so seeing that nobody has raised their hand to object, the flight plan is approved. So we'll look at the dispute settlement functions of the Council. We will look at the cases that the Council has dealt with or is in the process of dealing with in its 80-year history. We will look at what rules we are talking about, the rules for the settlement of differences, the establishment and the mandate of the working group that I referred to, the methodology that has been followed by the working group. I will give you an idea of some of the proposed revisions to the rules that the working group has come up with, as well as the substantive issues that the working group considered but did not make any proposals with regard to amendments. And then we would then look at the next steps in terms of where we go from here. So you will notice right from the beginning that I'm not talking about the judicial or the political function of the ICAO Council, but I'm referring to the dispute settlement functions of the Council. Article 84 of the Chicago Convention specifically says that if any disagreement between two or more contracting states relating to the interpretation or application of this convention and its annexes cannot be settled by negotiation, it shall, on the application of any state concerned in the disagreement, be decided by the Council. It continues, but I will not quote the entire provision. So, to start with, the dispute settlement functions of the Council are specifically related to disputes or disagreements relating to the interpretation or application of the convention, the Chicago Convention, and its annexes. And there is a requirement that those disputes cannot be settled by negotiation. And once you meet those conditions, then you can file an application before the Council to have that disagreement settled. Of course, as a fundamental principle of justice, no member of the Council is allowed to vote in the Council's consideration of any dispute to which it is a party. It's a simple principle of, no one can be a judge in their own cause. A decision made by the Council can be appealed either to an ad hoc tribunal agreed between the parties or to the International Court of Justice. I mentioned that the Article 84 specifically refers to disputes pertaining to the, or relating to the interpretation or application of the convention, but similar functions are conferred upon the Council in relation to the International Air Services Transit Agreement and the International Air Transport Agreement, both concluded in 1944 by virtue of Article 66 of the Convention. So Article 66 basically says that the organization shall perform those functions that are conferred upon it under the Transit Agreement and the Transport Agreement. And those functions include settling disputes that arise in relation to those treaties. So again, pardon me if you cannot read these slides. The intention is not to make you squint or to force you to wear glasses prematurely, but it's just to give you a very high-level summary of the cases that have been handled by the Council over its 80-year existence. So the first case was filed in 1952 by India against Pakistan. It concerned the establishment by Pakistan of a prohibited area along its western border, which made it difficult for Indian aircraft to fly over Pakistani airspace into Afghanistan. Sorry, my screen went blank for a moment. I wasn't sure what was happening. The provisions of the convention which were implicated were Articles 5 and 9, as well as the transit agreement. The second case, 1967, was between the UK and Spain. Again, it concerned the establishment of a prohibited area close to Gibraltar Airport, which the UK complained made takeoffs and landings from that airport unsafe. The third case, actually two cases, were filed in 1971 between Pakistan and India. Again, Article 5, the right of non-scheduled flight, as well as the transit agreement. It's interesting to note that in that case, there was a preliminary objection filed, and the Council's decision on that preliminary objection was appealed to the International Court of Justice, and it was upheld by the International Court of Justice. The next case is from 1996, Cuba and the United States. Again, it related to the right of Cuban aircraft to overfly US airspace during their flights to and from Canada. Again, Article 5 of the Chicago Convention. Up until then, Articles 5 and 9 seemed to be quite problematic for states, and so many of the disputes revolved around those articles. Fast forward to 2000, we have a case involving the United States and 15 European states. This was in relation to the Hashkit rule. The European regulations basically were more stringent than the ICAO standards relating to noise certification of aircraft. And this made it impossible for certain US aircraft which had been equipped with the Hashkit rule and which complied with the ICAO standards not to operate in the EU. The more recent cases start from 2016. Brazil and the US is still a case that is pending before the Council in certain respects. It relates to the interpretation and application of the Convention and its annexes following the collision in 2006 of a Boeing 737 aircraft operated by GOL Airlines and a private jet, an Airjet Legacy Embraer operated by XL Air Services Incorporated. It related basically to the interpretation and application of Article 12 of the Convention. In 2017, two cases were filed, which I'm sure many of you are aware of, by Qatar against Egypt, Bahrain, Saudi Arabia, and the UAE in the first case, known as Application A, which related to the interpretation and application of the Chicago Convention. And then the respondents in the second case were Egypt, Bahrain, and the UAE, and this related to the transit agreement, the right of overflight. The action has been discontinued against several of the respondents, but it's still pending in certain respects before the Council. In 2022, we received an application from Australia and the Netherlands against the Russian Federation, and this concerns the shooting down of flight MH17 in July 2014. This is still a live matter that is pending before the Council. After that, we had the Russian Federation filing a claim or an application against 37 member states of ICAO, alleging that these 37 states had taken unilateral unlawful measures in contravention of the Chicago Convention. This is still pending again before the Council. We have the most recent case, Canada, Sweden, Ukraine, and the UK against Iran from 2024. This concerns the shooting down of Ukraine International Airlines flight PS752 on 8th January 2020, and the provision of the convention which is implicated is Article 3 bis. So these are all matters which are pending before the Council, and so I would not go into any further detail. But if you've been following this, your states have been notified about the receipt of the applications and where we are in these matters. So, Article 84 of the Convention and Chapter 18 of the Convention, which deals with disputes, does not set out any procedure for the Council to handle applications received from states under Article 84. So when the first case was filed by India against Pakistan, there were no rules. And the Council decided then that it was important to have specific rules to help it resolve those disputes. And so it appointed a group of experts which deliberated and came up with rules which were adopted by the Council in 1957. Ever since those rules were adopted, they have only been amended once in 1975, and that amendment was simply to include Russian as an ICAO working language in the rules. Those rules apply to disputes submitted under Chapter 18 of the Convention. They define the procedure to be followed by the Council when it engages in the settlement of differences under Chapter 18. This process involves submission of written pleadings or written documents by the parties, as well as oral hearings. An important aspect of the rule is that the rules is that they encourage and facilitate the conduct of negotiations at all stages during the proceedings before a final decision is rendered. Of course, there is an ongoing process to review the rules, which is being carried out under the auspices of the legal committee. And this is the purpose of this presentation is to give you an update of the work so far done. It's important to note that any rules, any revised rules that are approved by the Council or adopted by the Council as a result of this process will not apply to any of the pending cases unless the parties agree specifically to that effect. So the working group on the review of the rules for settlement of differences, known in ICAO, we like our acronyms very much, so this group is known as the WGRRSD. The establishment of that group takes root from a Council decision in 2017, where the Council tasked the Secretariat to begin the process of reviewing the rules. Now, following consultation, it was agreed that the item would be added to the work program of the Legal Committee, and this decision was made during the 37th session of the Legal Committee, which was held in 2018, September 2018. So along with that decision, the Legal Committee decided that a working group should also be established to carry out the review, to start the process of the review, and that the members of that working group would be nominated by the chairperson of the Legal Committee in consultation with the President of the Council. So ultimately, the working group was established in May 2019 and has been at work since then. So between May 2019 and April 2024, or should I say September 2023, the working group has held 8 meetings in Montreal. So during that period, the COVID pandemic broke out, and so the working group had no option but to transition to a virtual format. So 4 of the meetings were held in virtual format, and 4 of the meetings were held in person. The membership is from 23 states, nominated by the chair of the Legal Committee in consultation with the President of the Council. The chairperson of the working group is Mr. Terry Olsen from France, which is one of the members of the working group. We had a vice chairperson, Ambassador Jailani from Indonesia, but he had to be replaced as he was no longer appointed as an expert on the group. So with effect from the 5th meeting, Mr. John Thatchett of Canada has been the vice chairperson of the working group. The group, with the endorsement of the legal committee, appointed a rapporteur from Singapore in the person of Mr. David Lowe. At the 8th meeting, the working group considered that it had completed the work that had been assigned to it, and therefore it adopted a final report which would be presented to the legal committee at its upcoming 39th session in June 2024. Now, appended to that draft report is a set of draft revisions to the rules that the working group proposes for the consideration of the legal committee. Now, in terms of methodology, the working group had the benefit of many benchmarking studies and research done by the Secretariat to identify different practices, relevant practices of international dispute settlement bodies such as the International Court of Justice, those named there, ICSID, the International Tribunal for the Law of the Sea, the Permanent Court of Administration, the UN Commission on International Trade Law, and the World Trade Organization. Now, during the course of its work, the Qatar cases, the Council made a decision on the preliminary objections in the Qatar cases, which were appealed to the International Court of Justice. And the International Court of Justice pronounced itself in July 2020 while the working group was still carrying on its work. And there are several instructive pieces of information from those judgments which the working group took into account in the conduct of its work. The working group also had, after many policy discussions, drafting proposals prepared by the rapporteur and the Secretariat, which were subsequently discussed and either approved or rejected. So in the next few slides, I will try to give you a taste of some of the revisions, proposed revisions to the rules that the working group came up with. So the first one is, of course, the scope of application of the rules for settlement of differences. As I have mentioned, Article 84 says that the Council shall decide any disagreement pertaining to the interpretation or application of the Convention and its annexes. But then we realize that there are other conventions. So we have the Chicago Convention, the Transit Agreement, and the Transport Agreement, or the Chicago Acts from 1944, falling within the scope of the rules. But we do realize that there are other treaties, other international treaties that have conferred dispute settlement functions on the Council. For example, the joint financing agreements between Denmark and Iceland, the Den-ICE agreements, for example, confer certain functions, dispute settlement functions on the Council. So the question was, do we expand the scope of the rules so that the Council can apply the same rules when it is seized with a dispute arising under those other treaties which are not specifically referred to in the Chicago Convention? There were extensive deliberations on this subject, and in the end, the drafting proposal that the working group came up with allows the Council somehow to extend its jurisdiction to these other disputes, but on condition that the Council has expressly granted its consent to undertake those dispute settlement functions. So ideally, when that treaty is concluded, the Council should be involved in the process and should agree to accept dispute settlement functions. In other words, two states cannot set up a treaty and just between the two of them say that the Council will be responsible for deciding any disagreements that arise under the Convention without the Council's agreement, and then that confers jurisdiction on the Council. So, but even with that drafting proposal, and I apologize that the drafting proposals do not appear on the slides, what will happen is that the report of the working group, along with the drafting proposals, will be published as a working paper for the upcoming legal committee meeting. So it will be accessible to everyone here. I encourage all of you to look out for it and to read it so that you are familiar with the proposals that are presented therein. But in the end, within the working group, there was a divergence of opinion. There wasn't consensus achieved on it. So the drafting proposal is placed in square brackets, and it is hoped that the legal committee, when it considers it, will be able to come to a decision, a final decision on whether to retain it or to jettison it. There are several other revisions, proposed revisions, which are aimed at just modernizing the rules. So for example, the current rules require that the agents for the parties must have an address at the seat of the organization. By an assembly resolution, the seat of the organization is the city of Montreal. So if you become party to a dispute and you appoint an agent, your agent must have an address, basically a physical address within Montreal. This can be a problem for some states that do not have resident delegations at ICAO headquarters. And also it could pose a problem because, I mean, in this day and age, documents are not sent exclusively by mail. So there was the need to modernize provisions, relating to these things by including the possibility for agents to have electronic or email addresses. In fact, today, when documents are sent in hard copy, we follow them up. Actually, we send them electronically before we follow them up with the hard copies. So this is just to catch up with what has become the practice today. There are a bunch of other amendments that are basically intended to reflect the principle of gender neutrality across the rules, across different linguistic versions of the rules. So, for example, you would see if you read the current rules that it makes reference to chairman, and there are gendered pronouns. If the respondent wishes to file a preliminary objection, he shall do this. So there's been proposed revisions across the board to get rid of these gendered pronouns and to make the language, the text of the rules, gender neutral. Again, similar provision to, similar proposals to those pertaining to email addresses and things of that nature. The rules require that documents must be filed, but they do not say that they should be filed in hard copy or electronic format. In reality, we do receive them in hard copy and in electronic format. So these amendments are intended to update the rules so that at least there is a legal basis for submitting an electronic format of a document. But noting also that we're dealing with legal proceedings, the working group thought that it was necessary to keep the old provisions which require hard copies to be submitted because you need to, at some point, be able to check the authenticity of documents that are submitted in these proceedings. In Article 2.1g of the rules, you will find that there is a requirement that when an application and a memorial are filed, they must contain a statement to the effect that negotiations have been carried out and they have not been successful. Negotiations to resolve the dispute have been carried out and have not been successful. Now, from the Secretariat's perspective, this created quite a bit of a problem because it is not clear whether the Secretariat is supposed to find out whether indeed these negotiations have taken place and have not been successful. Because when you read the rules, the Secretary General is supposed to verify that the application complies in form with these requirements, and this is one of the requirements. And when you read Article 84 of the Convention, it uses slightly different language. It just says that the application, the dispute or the disagreement cannot be settled by negotiation. So the proposed amendment, the drafting proposal, is aimed at aligning Article 21G with what is in Article 84 to make sure that the language is basically the same, to say that there must be a statement that the dispute or the disagreement cannot be settled by negotiation. And then things move on along those lines. The rules presently say that a preliminary objection may be raised if the respondent questions the jurisdiction of the council to handle the matter presented by the applicant. Now, in the ICJ judgments of 14 July 2020, there was an express decision by the International Court of Justice to the effect that preliminary objections may also be raised on grounds of admissibility of the claims. And so there is a drafting proposal to reflect that decision of the ICJ and to include admissibility expressly as a ground for preliminary objections. There are other proposed amendments. The rules currently as they stand do not make provision for the filing of written documents after a statement of preliminary objection has been filed. So what the practice in the organization has been to allow the other side to file written comments in response, and on occasion there's been replies and rejoinders and on and on. So the drafting proposal in the rule would be to give the opportunity for such written comments to be filed and no further pleadings in relation to the preliminary objection to be filed unless otherwise decided by the council. This is intended to provide clarity to the parties that you have only one round of pleadings, because there's been occasions in the past where just the written proceedings on the preliminary objection have gone on and on and on, and this has led to questions being raised about whether the council can actually have the opportunity to resolve the dispute or not. There are other provisions pertaining to whether or not negotiations may take place once a preliminary objection has been filed. Because when you read Article 5.4 of the current rules, they provide that once a preliminary objection is filed, no further steps shall be taken under the rules until it has been decided by the council. Meanwhile, in Article 14 of the rules, the council has that authority at any time to invite the parties to enter into negotiations. So the question is, when a preliminary objection is filed, does it mean that the council cannot invite the parties to enter into negotiations, or the parties themselves cannot enter into negotiations? The drafting proposal makes it clear that irrespective of whether or not a preliminary objection has been filed, the parties can still negotiate and resolve their disputes themselves, or the council can invite them to do so without infringing the rules. There is a provision in Article 18.2 which says that once a party decides to appeal against a decision of the council to the ICJ or to an ad hoc arbitral tribunal, this must be notified to the council within 60 days. Now, the question has been, what do you notify to the council within 60 days? Is it the actual appeal that has been filed, or an intention to file an appeal? Again, there was long deliberations, extensive deliberations on this, and the working group concluded that the intention is that the actual appeal must be notified to the council. So the drafting proposal introduces language to make sure that it is the submission of an appeal which must be notified to the council within the 60 days, not an intention to appeal, because you can intend to appeal and not appeal for 10 years. Article 29 of the rules sets out the languages within, in which the submissions may be made to the council. The sad reality is that even with the amendment in 1975, Article 29 refers to the 4 working languages of the organization. Currently, the organization has 6 working languages. So the proposed amendment is intended to avoid using a number to refer to the working languages, so that in the event that, let's say, in the future, the working languages are more than 6, there would not be no need to amend the rule. and it would be flexible enough to take into account all these changes. There's also a practice that has crystallized, in the Council's settlement of disagreements, basically to the effect that when pleadings and documents are submitted, only the actual pleadings will be translated into all 6 languages and not the supporting documents. Usually, the pleadings themselves are quite concise, but the supporting documents can easily run into thousands of pages. And if we have to translate all of them into all 6 ICAO working languages, you can imagine the financial and logistic challenge that would pose to the dispute settlement function. So the Council decided that only the actual pleadings will be translated and not the supporting documents, unless, of course, the Secretary General decides otherwise. This is reflected in a drafting proposal that will be presented to the Legal Committee. Now, on confidentiality, here I beg to digress a little bit. There's always this perception that the ICAO Council is a court, and therefore, when it's performing these Article 84 functions, and therefore should be open to all states, at least all contracting states and the public, when it performs these functions. But we have a rule in the Rules of Procedure for the Council, Rule 37 of those rules and Appendix F, when read together, are to the effect that when the Council is performing these dispute settlement functions, meetings should be held in closed session, which means that they're not open to the public, and the documents pertaining to those meetings should be marked as restricted, which means that they cannot be circulated outside the organization to unauthorized parties. On the other hand, when you look at Article 30 of the rules, Article 30 says that the Council, the proceedings of, relating to disputes shall be open unless otherwise decided by the Council. So you see that there is an inconsistency somehow between those rules. So there is a drafting proposal which attempts to reconcile these 2 provisions, which equally apply when the Council is engaged in the process of settling disputes. And it is also important to note that this drafting proposal emphasizes the Council's role in facilitating the negotiated settlements when it is dealing with disputes. There are some new provisions that the working group proposed. One of them deals with the Council's power to indicate provisional measures when it is dealing with a matter before it. The idea is that sometimes, if you look at the nature of certain cases, there is the need to limit potential damage to and to preserve the rights and interests of the parties, or to preserve the safety and security of international aviation. And therefore, there is a drafting proposal in a new Article 34 to the rules, which would allow the Council to indicate provisional measures when the circumstances so require. There's also a new provision which would allow the Council to issue practice directions. Again, with the multiplicity of cases that we've dealt with these days, we've realized that there are many, many areas where even though we have rules, they do not provide specific guidelines on what to do. If at any point in time there needs to be a new rule and the Council has to convene a working group or the legal committee, this would take forever. Mind you, the working group has been at this for the last 5 to 6 years already, right, just to try to amend the rules. So the idea is to give the Council the authority to adopt practice directions. Of course, practice directions will not be rules. They would not amend the rules, they would not supersede the rules, but they would provide guidance on practical issues in respect of which there is no guidance presently. The working group came up with a list of potential areas that the Council may issue practice directions. Of course, these are listed here, but they are more comprehensively discussed in the report and in an appendix to that report, which, as I mentioned, will be published as a working paper for the upcoming legal committee meeting, the 39th session. The other major area where a new provision was proposed is in relation to the conduct of virtual proceedings. Of course, with the advent of the pandemic, which made it impossible to hold in-person hearings and proceedings, it was important, necessary to consider alternative means by which the Council can perform its Article 84 functions in the event that in-person proceedings are not possible. So a new Article 36 has been proposed, which would allow the Council to conduct virtual proceedings, of course, with certain safeguards in place, one of them being that the Council must have due regard to the availability to the parties of technological means for such virtual proceedings. The other one being that the Council must consult the parties before making any decisions on how to conduct, whether and how to conduct these virtual proceedings. The working group considered many other provisions, but decided that amendments were not warranted. Some of them are listed on this slide here. I will not go through them to bore you too much, and seeing that I'm running out of time. There was one important issue that the working group discussed, how to interpret the term majority as used in Article 52 of the Convention. Article 52 says that decisions of the Council shall be approved by a majority of its members. Now, how do you determine a majority of the Council? Well, long story short, within the working group, some preferred an absolute majority. So the Council presently has 36 members. An absolute majority would be 50% plus one, right? Others preferred a qualified majority, in the sense that there are provisions that make certain Council members ineligible to vote in certain circumstances. For example, they may be party to the dispute, or they may not be party to the instruments in respect of which the dispute has been raised, the transit and transport agreement, for example. And therefore, that reduces the number of Council members who are eligible to vote. So if, say, you have 10 Council members involved in the dispute, the total number is no longer 36, but 26. If you insist on an absolute majority, it means you need 19 out of 26, but a qualified majority would be, say, 14 out of 26, or something along those lines. Despite the long deliberations, the working group could not agree on a specific amendment to this, and therefore, this matter is left for consideration by the legal committee, because it would involve basically an amendment or an interpretation of Article 52 of the Convention, which is not part of the rules. So I'm out of time, but in terms of next steps, the report will go to the legal committee in June. As I have mentioned, it will be published in all ICAO working languages. The legal committee at its 39th session will consider the recommendations, and then it will make its own recommendations to the Council, which has the ultimate authority to approve any revised set of rules. So thank you very much. I think I have come to the end.
Thank you very much, Dr. Nyampong. Now we will open the floor for questions and answers. We have about 10 minutes. Is there anyone who'd like to pose a question to Dr. Nyampong? I think if you're still considering, I'm going to pose one question, if I may. So you mentioned that in the revision of the rules, there will be the possibility of virtual proceedings. But I'm not going to ask you about that. You mentioned that the working group met virtually, especially during COVID-19. I was just wondering whether you could share some of the experiences on that with everyone.
Okay, that's a trick question from Siwei, as usual. The working group is a working group of the legal committee, and it does work within the rules of the legal committee. So within the rules of the legal committee, there wasn't any specific provision made for virtual meetings. The language is quite open. It says that the legal committee shall meet, right? So the interpretation that we took of it was that the provisions do not necessarily outlaw the conduct of virtual meetings of subsidiary bodies of the legal committee. Of course, this was not without controversy. There were several states that were not in favor of the working group meeting virtually. So the compromise that the working group came to was that any decisions or any points that were agreed upon in a virtual format would be opened for reconsideration when the working group convenes in person and would then be finalized. And I believe this was how the working group was able to carry on its work in spite of the challenges brought up by the pandemic.
Thank you very much, Dr. Nyampong. Do I have any questions from the floor? Anyone? No, then if you don't mind, I'm going to ask you a second question. And the second question is this. You mentioned that these revised rules will be considered by the legal committee, and I said so myself. So would you have any suggestions to states on preparing for the legal committee session deliberation on the revised rules?
Yes. So the suggestion that I would have for states is that, number one, participate in the legal committee session. The legal committee is open to participation by all member states of ICAO. It's not like the other committees that are of limited membership. Legal committee is open to participation by everyone. So please make sure that your state participates. When you go back, start, speaking to the people that make those decisions to make sure that they send you or they send someone else, preferably you, to the legal committee meeting, the session that is coming up in June in Montreal. So your presence there is number one, almost 90% of the equation. Secondly, all the working papers that will be considered by the legal committee will be published in advance of the meeting. And there will be a website set up. So all these papers will be available in all 6 ICAO working languages. So please make sure that you have downloaded copies of the papers, you have read them, you have done your internal consultations, and that when you come to the meeting, you are able to express your position on those papers, on the outcomes of the work that is presented for consideration by the legal committee. I'll leave it there.
Thank you very much. Does anyone have any question? Yes, I see a hand over there. Could you identify yourself before you ask your question?
Thank you. Can you hear me? Okay. Yeah, my name is Jay Kim. Now I'm working as an international affairs coordinator at the Supreme Court of Korea, and for the last 3.5 years, I worked as an alternate on the ICAO Council of the Republic of Korea. Thank you for the presentation, Mr. Nyampong. And my question is related to the current revision work of the dispute settlement regulations, rules on the dispute settlement. Actually, my understanding is that the character of dispute settlement under the current rule is usually regarded as a political natures dispute settlement. But my question is that, is there any suggestion to get more lawyers involved during the dispute settlement deliberations or dispute settlement discussions? Thank you.
Thank you. Thank you for the question. This was an issue that was deliberated upon at length by the working group. In the first few meetings, there were what the chair used to refer to as philosophical discussions about the nature of the dispute settlement function of the council, whether it is a judicial function or a political function. But after a while, the working group came to the realization that that discussion would really not help in resolving, the task that had been assigned to it. In the sense that whether it is a judicial body or a political body, it has certain functions and it must be able to perform those functions. Of course, the council is, comprises 36 member states, and each of those 36 member states has the discretion to appoint a representative and several alternates as they wish. Nothing stops the member states from appointing people who have, or representatives who have legal training when the council has to deal with a matter that is of a legal nature. But that is not to say that the council then becomes a court of law, strictly speaking, in that sense. In fact, the International Court of Justice in the Qatar case did issue a pronouncement to the effect that the concept of judicial propriety does not apply to the ICAO Council because the council is composed of representatives who are not sworn judges and so forth and so on. So again, there's that debate that goes on, but that, in the view of the working group, does not help in resolving, helping the council perform its dispute settlement functions as laid out in Chapter 18 of the Convention. In fact, that's why we no longer refer to the judicial or quasi-judicial functions of the council, as you would see in some of the literature, but we just call them dispute settlement functions. I hope I've been able to answer the question.
Thank you very much. Anyone else? I think there's a hand over there. Am I right?
Thank you very much. Posesi Bloomfield from Tonga. Disputes can also happen between less developed countries. In many cases, you would agree they would need the most help to protect their sovereign rights under the convention. So like any civil court of law, the prohibitive costs of bringing a dispute to the council can be a barrier or a disincentive for participation. So my question is, what measures, if any, have been considered to allow greater access by parties who have a dispute, a legitimate dispute, because otherwise this just becomes a mechanism accessible to some and not all members?
Do you want to answer that, or shall I?
I can attempt by just saying that, while I'm I fully agree with you about the prohibitive cost. I must also say that the filing of an application before the council does not involve paying filing fees. Your costs are, elsewhere, but not in accessing the council. You may have to recruit, the expertise to write your application and your memorial, but you have to do that in any event because you need to present a case, right? But in order to access the council, you do not need to pay any money. In fact, even translations are borne by the organization. And in fact, this is a heavy burden. The translation of the documents that are filed in one ICAO language into the 5 other ICAO working languages are funded by the, the contributions of member states. That's all I'll say for now.
Thank you very much. Yeah, I was going to do the lawyerly bit and say that I think this aspect was not within the mandate of the working group. So we would not be able to give you really a comprehensive answer, but I think Dr. Nyampong has done a great job in addressing your question. So any last question? Otherwise, I'm going to move on to the next topic. There is one more? Someone? One last question.
Thank you. Good afternoon. I'm from China and working for the Civil Aviation Management Institute of China. I have a question for Dr. Nyampong. You just mentioned the working group identified relevant practice of other international dispute settlement bodies, especially the ICJ judgments. So I want to know how judgments of ICJ are used in ICAO dispute settlement mechanism. Are they can be used directly as conclusion or just as important references? Thank you.
Again, a good question. So I should have issued a caveat in that regard to say that the benchmarking studies that were done were not in relation to the judgments of the ICJ in particular. What we looked at were the rules that apply to the ICJ when it does its job, right, as against the judgments issued by the principles of law that are established in the judgments issued by the ICJ. But I did refer to the decision of the ICJ in the Qatar cases because these were decisions that were made in relation to appeals from decisions of the Council. So under Article 84 of the Convention, the decisions of the Council are appealable to the ICJ, and the decisions of the ICJ from those appeals are binding on the parties. And therefore, we look to those specific decisions for guidance on what the ICJ says. And because the nature of the work was in relation to the rules applicable to the settlement of differences, we did not specifically look at the broader, principles of international law as, set out in ICJ decisions that have nothing to do with ICAO.
Thank you very much. I hope that addresses your question. So we have to move on to the next part, but I want to thank Dr. Nyampong for such a great job in explaining the revised rules and the work that went behind it, as well as addressing all the questions. So before we move on to Dr. Lee, can I just ask for a show of appreciation for Dr. Nyampong? Thanks again. And then just before we actually move on, I'll just give a reminder that the revised rules, when finalized and approved by Council, will apply only to future disputes and not to the current disputes that are already filed before the Council. Thanks again. So now it's my pleasure to introduce Professor Lee Gunyang of the Korean National University of Transportation. Before joining this university, Professor Lee was in charge of planning and implementation of international cooperation and collaboration at the Office of International Program and Policy of MOLIT. He was the Republic of Korea's national coordinator for the ICAO USOP and has played a vital role in establishing and expanding aviation safety in this country. Before I hand the floor, however, to Professor Lee, I mentioned earlier that I'm going to give a rather long introduction. And the reason for this is that I'm also going to share some thoughts on the subject of how the Chicago Convention has worked over the last 80 years. And the reason why I'm doing that is originally we intended to have 2 speakers for this part of the panel. And so I exercised a bit of moderator license to say some words. It's going to take a few minutes long, so it's not going to be that short, but it's not going to be too long. So first of all, I will put my opinion right out front. I will say, I think the Chicago Convention has actually worked really rather well. And I will say that the reason for this is that it has actually seen aviation through ups and downs over 80 years. with only 2 substantive amendments, Article 3 bis and Article 83 bis. The aviation downs, including crises and shocks in more recent times, include Y2K, 9/11 in 2001, SARS, and our region knows that very well, in 2003, the financial crisis in 2008, the eruption of the Icelandic volcano with that really unpronounceable name, and that resulted in the closure, unprecedented closure of European airspace. And we thought that we already seen that in 9/11. And then, of course, the B737 MAX grounding, the COVID-19 pandemic. Who would have thought that we would be seeing that 1 in 100 years event? Each time, thankfully, aviation has survived and bounced back. The convention has served as a cornerstone of international civil aviation regulation, fostering cooperation and standardization among nations. Over the decades, it has enabled the growth of air travel, ensuring safety, security, and efficiency in air navigation. The Convention has, with its principles of sovereignty, non-discrimination, and cooperation, provided a broad framework for promoting sustainable development, advancing technological innovation in the aviation industry, and resolving disputes, as you have just heard. Its enduring relevance underscores the adaptability to evolving challenges and opportunities in the ever-changing landscape of air transportation. So how has all this been possible under the Chicago Convention? Much has been written about the Chicago Convention. I just would like to mention a few factors that I think has contributed to its success. First, flexibility in setting standards and allowing for differences. The predecessor agreement, the Paris Agreement, actually made the annexes part of the agreement. And the trouble with that, or the challenge with that, is that if you become party to that agreement, and if you do that for the convention, then it makes ratification something rather more difficult for states to consider. And if they are made mandatory without any room for some kind of a, for want of a better term, escape clause, would really make states pause to become party to this convention. So it would not have been possible to obtain the almost universal adoption of the convention if the standards had been mandatory and there were no differences. It would also not be possible to continuously adopt practical standards to address challenges unanticipated in 1944, such as cybersecurity, climate change, unmanned aircraft, and other technological developments in a timely manner. Second, flexibility of the Council's remit and function. The ICAO Council may consider almost every matter, so long as any contracting state refers to it as a matter relating to the Convention. And the objectives of ICAO are, I would say, somewhat broad and flexible. Based on this, the ICAO Council, supported strongly and very ably by the Secretariat, is able to deal with emerging issues not foreseen in 1944, such as the sustainability issues that are now priority for us as an aviation community. And other issues like artificial intelligence, space-related issues, and other issues we cannot even imagine today. Third, and this I think is going to be a little bit controversial, but I'll say it with input from a good friend, avoiding traffic rights issues by leaving them in a way to out of the convention and bilaterally. The issue of whether ICAO should deal with air traffic rights or not almost dominated the discussions in the 1944 Chicago Conference and eventually led to the Bermuda system. Some say it was a failure of the conference and the Chicago Convention. However, Actually, air traffic rights were dealt with at the during the 5 weeks of the Chicago conference, and resulted in two separate instruments, the Air Transit Agreement and the Air Transport Agreement. And if you look at the record, if I may say, of the Air Transport Agreement, there are only, I think, about 11 states, am I right, that are parties. That tells you everything, I think. If you had included air traffic rights in the Chicago Convention, would we have 193 states today? I'm not sure. So considering the complex nature of traffic rights with the associated elements of national pride, security, among others, and the current difficulties in other economic international organizations, it may also well be that not including the air traffic rights in the Chicago Convention has allowed the convention the success that it has today. But above all, my view is that the greatest success factors are: one, the creation of ICAO. Without the organization ICAO, which operates under the able leadership of the Council and strongly supported by the Secretariat, we would not have the evolving standards to meet the challenges and the issues that were not faced in 1944 and they're not going to be faced today. So the continued relevance and increasing support of ICAO is evidenced by the huge participation in its events. And even today, the reference of disputes to the Council for resolution. So I think there are another two, I will end here and I will call upon Professor Lee to make his presentation. Thank you very much. Professor Lee, please.
Thank you, Ms. Tan, your generous introduction about the Chicago Convention and myself. Once again, I'm Professor Lee Geun-young of the Department of Aeronautical Science and Flight Operations at the Korea National University of Transportation. It is my honor and privilege to deliver my presentation material in front of all distinguished participants and guests. In addition, it is also even more meaningful because it's the first international conference to be held since my election as a president of the Aerospace Policy Law Association in Korea. I can see many participants from my association. What I'm going to say is explaining about the relationship between the Chicago Convention and the Republic of Korea. And I'm going to tell you how the Chicago Convention is still ineffective even 80 years later. At the end of my presentation, I would like to talk about new concepts and technologies that need to be reflected in the international civil aviation treaties. As you're all aware, representatives from 54 countries were invited to Chicago at the end of World War II to work on creating an international agreement on international civil aviation. The Chicago Convention came into force in April 1947. At that time, the Republic of Korea was not in the list of the participants because we are in the colonized by Japan. As you can see in my slide, the Chicago Convention has been amended several times since its enactment. However, its spirit and the philosophy are still very effective. Among the amendments to the Chicago Convention, Article 3 bis, non-use of weapons against civil aircraft in flight, is an amendment caused by an aircraft accident registered in the Republic of Korea, Korean Air 007, which was shot down by a Russian fighter jet. Since then, the number of interception accidents of fighter jets are significantly reduced. Let me tell you about the relationship between the Chicago Convention and the Republic of Korea. In the Republic of Korea, we ratified the Chicago Convention during the Korean War to recognize its importance in aviation field. Article 1 of the Korea Aviation Safety Act declares that Chicago Convention is faithfully implemented in Korean Aviation Act. This means that Republic of Korea is promoting safe operation by reflecting international standards and recommended practices by ICAO, and it is implemented in domestic law. Various aviation-related academic societies are actively working in the Republic of Korea. Among them, the most related to this seminar is the Korea Society of Air and Space Law and Policy. More than 300 scholars, lawyers, and legal representatives serve as members of that society. We publish paper books 3 times a year, and also we conduct presentations and discussions by holding academic conferences several times in a year. Although the Chicago Convention was created 80 years ago, it is still very active as an important convention. I would like to introduce some interesting articles. First one is Article 8, pilotless aircraft. The review of UAV, which has only recently been rapidly developed, and the concepts were already reflected in the Chicago Convention 80 years ago. Even though the concept is slightly different to advanced urban air mobility at this time. I will choose Article 14, prevention of spread of disease. Global pandemic was predicted 80 years ago at Chicago. And the COVID-19 was the biggest impact event in the history of air transport. The COVID-19 pandemic has caused an unprecedented crisis for air transportation industry and affect millions of aviation users and stakeholders. It requires a useful framework for a coordinated global response to future disease outbreak. From now on, I would like to tell you about the Chicago Convention, about the future to overcome. For the development of aviation industry, it is necessary to remove barriers. One of that barrier is airline substantial ownership and effective control. The nationality clause criterion has been used since the 1940s. Over the past decades, liberalization, privatization, and globalization have significantly changed the air transportation industry. States can liberalize airline ownership and control through various means. And I think ICAO can initiate the development of an international agreement for states to liberalize airline ownership and effective control area. There are also several measures to remove barriers. One of that is easing market access and utilizing multilateral convention, or some cases, interregional air transport agreement utilization. Aviation consumer protection is important for the development of aviation industry recently. The trend of selling and purchasing airline ticket is electronic means. There are various players such as airlines, ticket sales agencies, travel agencies, and consumers. Consumer damage is also caused by the collision between E-commerce Act and the Aviation Business Act. ICAO level rulemaking on electronic transaction of airline tickets is expected to be an important step toward better consumer protection area. The Chicago Convention to stop the spread of an epidemic is a very important concept. However, in the face of a global pandemic, such as COVID-19, air transport industries were very helpless. So we need additional solutions. Non-contact technologies, such as facial recognition, are critical to prevent the spread of infectious disease. The development of these contactless technologies and the spread of their applications through ICAO are very important. Let's thinking about the artificial intelligence, which Ms. Tan already mentioned. New technologies using artificial intelligence are now beginning to be used in many parts of our society. Attempts are being made to allow robots equipped with AI to perform repeated and simple tasks instead of humans. These attempts are expanding into more complex and comprehensive fields, which we call strong AI. Legislative activities are needed to ensure that application of these advanced technologies in the aviation sector is important. Let me summarize my presentation with the slide. The Chicago Convention was created 80 years ago, but is still very useful and effective today. Second, the Republic of Korea recognized the importance of the convention even during the war, and our government ratified it. Third, Chicago Convention needs to be revised progressively to develop the air transport industry in orderly and effective manner. Lastly, the development of the Chicago Convention requires ICAO, government, industry, and academic experts to work together. Thanks a lot for your kind attention.
Thank you very much, Professor Lee. So we do have some time for questions and answers, but I want to make a suggestion. Instead of questions, I'm going to ask for thoughts and views from everyone on how the Chicago Convention has worked for 80 years. I'll just add that Professor Lee mentioned about, and many other people have mentioned about the standards and in relation to the revision of the Chicago Convention. I think the Chicago Convention, because of the annexes, not strictly speaking in the convention, but is considered to be part of the Chicago Convention, allows for changes to be made over the years. And one of the challenges is that actually we now have accumulated something like, that figures kind of vary, 12,000, 13,000. So the CAAs that have to implement them and the industry that have to, well, work under them, it is quite a lot to deal with, especially for the smaller CAAs where the resources are very few. So I think that's one of the challenges. I think the interesting thing is that because ICAO is aware of this issue, ICAO has in fact taken steps to try and alleviate and to address this challenge. The other thing that Professor Lee has mentioned is about collaboration and cooperation. And I think this is also one of the success factors, that ICAO and the Chicago Convention, rather, has allowed for an ICAO that focuses on technical safety and security standards and other technical standards. And it's this focus, despite or with political elements, that actually has allowed for ICAO to do a very successful job, albeit with difficulty, albeit with tight resources, and so on. But a marvelous job nevertheless. And I think that what's really important at the end of the day is the unity and cooperation that is incorporated and institutionalized within the institution of ICAO because of the provisions of the Chicago Convention. If you read the preamble, which was created in the time of war with the aspiration of peace and the development of the world, and non-discrimination, even though in a war there are winners and there are losers, right? But one state, one airline was the aspiration. What a marvelous aspiration, despite the fact that if you look at the circumstances in which the Chicago Convention was born. And if you look at the provisions of the Council, for example, mutual recognition, okay? Notwithstanding that countries have differing resources and capabilities and so on. And if you look at Article 84 itself, the element of negotiation, I just recently was listening to a seminar on other dispute resolutions, arbitration in other international organizations. And one of the interesting elements is that Article 84 incorporates the need for negotiation. And I personally like the word difference rather than dispute. I think there is a difference in the connotation. And so I think we are really the beneficiaries of a treaty and an organization that was built on this treaty that has really made cooperation, collaboration the core of its existence, and that has allowed aviation to flourish. So I do see that our MC has come on stage. Does that mean that we have no time for any other contributions?
Maybe one or two comments would be okay?
Okay, thank you very much. Yes, anybody dying to contribute, it'll be great. Anybody? Your thoughts on the Chicago Convention and how it has worked for 80 years? I see somebody.
So thank you immensely to the panelists and the moderator for this interesting presentation. I'm Graham McFannell from the Department of Foreign Affairs of Canada. And I think I just wanted to take this opportunity to second Mr. Lee and his reference to Article 3 bis as a milestone of the Chicago Convention over the last 80 years. It demonstrated the ability of states to take on an important issue that wasn't covered under the convention, and I think is indicative of the fact that it is only one of two substantive amendments to the convention. So it really is an important milestone, and I think it's something that we can reflect on today as we discuss the importance of aviation safety. So thank you.
Thank you very much. I just want to underline that ICAO recognizes the importance of civil-military cooperation, and this has been part of its work over many years as well. Anyone else? No, I don't see anybody. Okay. In that case, I just want to underscore again the importance of the Chicago Convention and the extent to which it has contributed to civil aviation and the aviation community that we have today. So I think kudos to the founders and kudos to everyone, all present here and not here, who have made it work so well. May we all continue to collaborate, cooperate, and work through the difficulties. Never ever say that we cannot agree, and therefore we have to do something drastic. If possible, let us just cooperate, address the challenges, and bring aviation to greater heights. Thank you very much. And thank you very much to Professor Lee and Dr. Yao Nyampong for great presentations. Thank you very much. Thanks, everyone.
Yes, thank you very much. That brings us to the end of all the sessions prepared here at 2024 ICAO Legal Seminar. It was a great chance for us to gain new insights on the current issues in the aviation law and practice. Well, ladies and gentlemen, we're now going to move on to the last coffee break that has been sponsored by Asiana Airlines, Jeju Air, TUA Air, Jin Air, and Air Busan. Please enjoy the refreshments prepared for you, and we'll be back for the closing ceremony at 4 o'clock. Thank you very much. Well, ladies and gentlemen, it's time for us to move on to the closing ceremony. Well, during the break time, I was able to see participants taking pictures with each other, trying to capture this moment. Well, then I must ask, how was the 2 days here with us at the 2024 ICAO Legal Seminar? Great? Superb? Okay, I hope that it was just beyond your imagination. Well, coming to the closing ceremony, I hope that with all the memories that we have made together, we will be able to keep on flying together in order to make a bluer sky. Well, in order for us to close the event, we're going to welcome to the stage Mr. Michael Gill, the Director from the Legal Affairs and External Relations Bureau of ICAO, to deliver his farewell remarks. Ladies and gentlemen, let's welcome him to the stage with a big round of applause.
Thank you very much. Excellencies, Honourable Ministers, Directors General of CAA and Director General Yu from the Minister of Land, Infrastructure and Transport of the Government of the Republic of Korea. Thank you for joining our closing ceremony. We've had a very full and intense 2 days of discussions, but I think it would be somewhat remiss of me not to recap on the events that we've taken part in over the last 2 days and what has been an extremely rich and successful ICAO legal seminar. As we noted, this event continues to go from strength to strength, with this year some 752 participants from 78 states attending either here in person in the wonderful city of Seoul or following the event by live streaming. And we've expanded the content of the seminar to cover a whole range of new topics. I learned a great deal, for example, about the role of the regional safety oversight organizations, the significance of air transport facilitation, and many of the legal issues arising from that. And it was, I think, extremely positive to hear about new and emerging issues of interest to the aviation legal community on areas like data privacy and air transport, and legal issues arising from new technologies in aerial mobility. We highlighted a number of significant legal developments in aviation safety. We renewed our calls to member states to ratify air law instruments, and we heard a great deal about the benefits and the processes and the actions that states need to take to move forward with ratification, including some of the substantive air law treaties and the protocols to the Chicago Convention, which expand the membership of the Air Navigation Commission and the Council. We heard this afternoon the outcomes of the work that's been undertaken over the last few years to review and develop new procedural rules for the settlement of aviation differences by the ICAO Council. And that is a topic, of course, which is growing in frequency and scope. And of course, we've commemorated here the 80th anniversary of the adoption of the Chicago Convention, taking place in December of this year, and the many achievements that the Chicago Convention has brought to the aviation sector. So overall, I really hope that the information you've heard, the experiences you've gained, will assist all of you in your day-to-day work, and will also assist you in preparing for our upcoming session of the ICAO Legal Committee in Montreal in June, and then our preparations collectively for the 42nd session of the ICAO Assembly in the autumn of 2025. We had two extremely interesting and rich side events organized here this week. Also, the open debate with the next generation of aviation professionals, which I personally find extremely inspiring and rewarding. And then a high-level forum which took place this morning, bringing together the ministers and a number of senior officials from member states looking at broader aviation policy issues. Now, just as important as the content, and I wanted to echo the sentiments expressed by the Secretary General, this event has really been about friendship, and that's thanks to all of you, the special relationships which we build over the years by attending these events, and the new friendships that we can make when we come together to discuss topics of common interest. But it's also an event that's been about the special energy that one feels when one comes here to the Republic of Korea, and which has really enhanced all of our collective experiences. So I think I speak for everybody when I say that we'll take back home many, many memories of the meetings here in Seoul this week and the interactions which we've all had. So let me close by expressing again our sincere appreciation to the Ministry of Land, Infrastructure and Transport for their consistent generosity in hosting this event. I also wanted to thank all of the speakers and the facilitators from member states, from international organizations and from the industry who've joined with my team in the ICAO Legal Bureau in sharing their valuable insights, sharing their expertise on a whole range of very important topics. I do want to thank our very articulate MC who has kept us on track. She's kept us on time and made sure that our event has run very smoothly. And I wanted to give a special recognition to Leah Sunok Lee and Alice Kang and their respective teams for their coordinating roles in bringing the event together. And a final word to our colleagues in the delegation of the Republic of Korea at ICAO and in the government of the Republic of Korea here in Seoul for all of their strong support and the excellent collaboration which we've seen as we put this event together. Let me close in thanking them. Let me close in thanking all of you for your contributions and your participation, and we look forward to seeing you at a future event. Thank you very much.
Thank you very much, Director Michael Gill, for the farewell address. It was really good to hear from him personally that he makes a lot of good memories here in South Korea. Well, as he have mentioned, we had a lot of exciting discussions together throughout the 2 days, and I believe that these exciting discussions will serve as a pillar stones for us to have more productive gatherings in the future. And now moving on, I would like to invite to the stage for the closing remarks, Mr. Yoo Kyung-soo, the Director General for Aviation Safety Policy of the Ministry of Land, Infrastructure and Transport of Republic of Korea. Let's welcome him again with a big round of applause.
여러분 이틀간 수고 많으셨습니다.
Thank you for your great efforts for the 2 days.
Gentlemen, moderators and speakers who have offered us great insight by their presentation and discussion. Thank you very much. I have no doubt that this year's ICAO and MOLIT legal seminar was particularly more invaluable and future-oriented than any other events. It's all the more meaningful that this year marks the 80th anniversary of the Chicago Convention. Over the last 2 days, with the presence of the international aviation expert, we addressed new topics in safety, security, and technology, as well as the ways to safely restore their connectivity and build a sustainable future for post-pandemic era. Discussion was very timely and productive. It allowed us to reflect the emerging challenges in the new era of mobility, such as the integration of the innovative technology into aviation system and potential difficulties lying in our journey toward more resilient and greener international aviation. I expect outcomes of discussion to be forwarded to ICAO Committee and Council and develop into international standards and recommended practice for enhanced international civil aviation. Once again, I appreciate all the presenters and participants, interpreters and organizers and ICAO staff for all their hard work. Distinguished guests, I appreciate your presence today and I wish to see you again at the upcoming ICAO events. Going forward, the Republic of Korea, as an ICAO member state and Council member state, will put its utmost effort to facilitate growth and the development of global civil aviation. I once again extend my profound gratitude to all of you for gracing us with your presence. I wish you safe journey back home. Bon voyage. Thank you very much. 감사합니다.
Thank you very much.
Thank you very much, Director General Yoo Kyung-soo, for the closing remarks. Well, ladies and gentlemen, this brings us to the end of our seminar, which is another successful collaboration between ICAO and MOLIT. If you think that this was indeed a successful one, please give a big round of applause. And of course, I would like to express my sincere gratitude to all the moderators and speakers for giving their insights. So to thank them enough, let's give them another big round of applause as well. Thank you very much for sharing your insights. And of course, for the last but not the least, our thanks goes to all the participants who have joined us throughout the 2 days, here offline and also online. So to thank all of our participants for the participation, let's give another big round of applause. Thank you everyone for being here with us today. Thank you. Well, ICAO Legal Seminar will be back next year with another abundant contents to discuss in the platform. So, ladies and gentlemen, thank you very much for being here with us. And until next time, goodbye. 고맙습니다.
Thank you very much.